Dzień dobry, witamy Państwa bardzo serdecznie po raz kolejny w Rzeszowie.
Ladies and gentlemen, we would like to welcome you once again in Rzeszów, and Agata Ludera-Ruszt will open the conference officially.
Dzień dobry, Szanowni Państwo. Pani minister rodziny i polityki społecznej Marlena Maląg wystosowała do nas list w związku z...
Ladies and gentlemen, I'm afraid we have some slight technical problems.
Pozwolę sobie ten list w tym momencie odczytać. Otóż, Szanowni Państwo, zmieniające się otoczenie środowiska pracy i pojawiające się nowe technologie stawiają przed nami...
Reading a letter. I do apologize, but interpreters hear themselves, so there are some slight technical problems. When they are removed, interpretation will be resumed.
Przestrzegania prawa pracy. Bardzo ważnym aspektem tych problemów jest umożliwienie pracownikom godzenia życia rodzinnego i wychowania dzieci z pracą zawodową. Temu między innymi będą służyć propozycje zawarte w to gwarancja stabilnych i jednolitych warunków zatrudnienia.
Very important. No, sorry, still there is a echo, and interpreters hear themselves. Sorry, for the time being, interpretation is not possible.
Tarczy branżowej był kilkukrotnie rozszerzany. W sumie wsparcie otrzymało 65 branż wskazanych.
65. No, still there is an echo and interpreters hear themselves, so they do not hear the speaker. No.
Prawa pracy w taki sposób, by odpowiadały one oczekiwaniom zatrudnionych i potrzebom pracodawców. Jestem przekonana, że druga międzynarodowa konferencja naukowa
Convinced, still nothing. I do apologize. I still make attempts, but I'm afraid I cannot interpret at the moment.
Instytutu Rzeszowskiego, Zakład Prawa Pracy w Instytucie Nauk Prawnych Polskiej Akademii Nauk oraz Instytut Prawa Pracy i Polityki Społecznej dzięki udziałowi wybitnych specjalistów pozwoli na sformułowanie odpowiedzi na wiele pytań z tego obszaru. Cieszę się, że mogłam objąć to wydarzenie patronatem honorowym. Uczestnikom konferencji życzę owocnych obrad i twórczej wymiany myśli. Niech jej owocem będzie rynek pracy. Serdecznymi pozdrowieniami i wyrazami szacunku. Minister Rodziny i Polityki Społecznej Marlena Maląg. Dziękuję bardzo. Dziękuję bardzo Pani doktor. Proszę Państwa, Jego Magnificencja, rektor Uniwersytetu Rzeszowskiego, Pan Profesor Sylwester Czopek, niestety z powodu obowiązków nie mógł otworzyć naszej konferencji.
Good morning.
Niezmiernie miło być w tym miejscu na tej konferencji, której tematem jest pojęcie
Topic.
i pracodawcy. Jest to druga międzynarodowa konferencja naukowa, już, czyli można powiedzieć, już zaczęty jest cykl, tak? Mamy nadzieję też, że tak jak mówiła pani profesor Kowalczyk, będą kolejne konferencje i na stałe to wydarzenie naukowe wpisze się w kalendarz zarówno naukowców, jak i czy praktyków i praktyków zajmujących się prawem pracy. Jest mi oczywiście niezmiernie być tutaj, otwierać tak zacne wydarzenie naukowe. Tym bardziej, że sama z racji wykonywanego zawodu też jestem prawnikiem. No niestety nie zajmuję się na stałe prawem pracy, ale zbliżoną tematyką, chociaż u pana profesora Wratnego zaczynałam na seminarium. Także coś z tego prawa pracy zostało mi w głowie, panie profesorze. Dziękuję za to. Organizatorzy konferencji postawili sobie cel. Tym celem jest odpowiedź na pytania o potrzebę redefinicji tych pojęć, czyli pracodawcy i pracownika wobec
So now another attempt. I do apologize. Not yet. Interpreters still hear themselves.
Pracy w kontekście takich procesów zachodzących we współczesnym świecie, jak globalizacja gospodarki, dążenie do coraz większej elastyczności uczestników obrotu gospodarczego i rozwój nowoczesnych technologii. Cel szczytny. Ważne jest to, żeby w nowym otoczeniu, w nowej...
And I would like to try and make an attempt of translation. Sorry, the technical problem was not solved yet because interpreters hear themselves and they cannot interpret into the English language. I do apologize.
Pracodawcy i pracownika i jakie teraz należy rozumieć. Ze swej strony, jako dziekan Kolegium Nauk Społecznych, jest mi niezmiernie miło być tutaj, to co już zresztą powiedziałam, i mam nadzieję, że zarówno dla uczestników tych stacjonarnych, jak i tych zdalnych konferencja przyniesie wiele korzyści i cel jej zostanie osiągnięty. Także życzę owocnych obrad.
I hope you have a fruitful debate and thank you for your attention. All right, so now interpretation into English has begun, and now we have a rector of the University of Humanities, so please take the floor. Thank you very much indeed, Professor. Ladies and gentlemen, I had an opportunity to talk to the magnificent rector of the University of Rzeszów. We had a conversation about something else, but he asked me to convey you best wishes and he hopes you will have a fruitful debate. So I have a pleasure to replace him. I'm not a lawyer, so I'll be much briefer than Madame Dean. I'm not a lawyer, but I have something in common with the labor law. Elżbieta Ferenc could not participate in the opening ceremony, and I'm very glad I am here myself because in my scientific research I dealt with a lot of political, social policy and related topics. So I would say that in Polish social policy, not much has changed for the last 100 years. We are still trying to define who an employee is, who an employer is. We have the same problems. Various levels of salaries and remunerations, labor law and its resolutions and provisions. So various situations require reactions of lawyers, employers, and organizations of employees. After 100 years, it should have changed. Yes, well, it has been changing, but I'm not really sure whether it is going in the right direction. So I want to congratulate on organization of the second scientific conference, and I hope I will meet you at the 10th, 15th edition of the same conference. I hope it will happen. And I wish you all the best, and I mean here both on-site participants and online participants. I hope you have a very fruitful debate and good meetings face-to-face, and I hope that the results of the conference will also meet the expectations of Madam Minister. Thank you. And now I'd like Director of Legal Sciences Institute to take the floor. So, Mr. Maroń, the floor is yours. On behalf of the Institute of Legal Sciences of the University of Rzeszów, I would like to welcome you to the conference on the concept of employee and employer. Welcome to all the people here in the room physically, but also welcome to our online participants. You represent more than 30 academic centers and research institutes from Poland, including several other institutes from abroad, from Europe, from other continents. We have remote participants from the US, Taiwan, and India. Now, I would like to say thank you to the Labor Law Department for preparation of this event, headed by Professor Aneta Kowalczyk, together with the Labor Law Department of the Polish Academy of Sciences, because I know that organization of such a scientific event on site at the time of pandemic is connected with a risk, because there might be more limitations, there might be developments of the pandemic situation, and the conference may not take place. And today we can see that the risk was worth taking, because the conference is beginning right now. At the moment, in individual legal sciences, we can observe a certain trend to focus our attention on the issues which are getting more and more detailed, because basic issues seem very well known and analyzed in a very comprehensive way. But you decided to go back to the roots. You are discussing two fundamental issues of an employee and an employer. And I have made an overview of the titles of the papers at your conference, and I can see that the topic is very well justified, because conceptual categories of an employee and an employer are still a very attractive subject of scientific exploration. We should think about these issues, talk about these issues. It is actually indispensable to analyze them further and make a reflection upon them. The social reality, the dynamics of social relations requires us to do so. The labor law is among the fields of law which pertain to social relations involving millions of people. I cannot say the same about my field, which is the theory of philosophy of the law. So your explorations, your investigations, your discussions are not only of academic value. I would like to say that many conclusions that you will come up with sooner or later will be reflected in the legal regulations pertaining to millions of employees and tens of thousands of employers. And I hope that your conclusions, your reflections will be made available, whether in the form of a monograph or perhaps papers in scientific publications. So I hope you will have a fruitful debate. I hope you will have an interesting pool of conclusions full of erudition and in-depth analysis, but I hope they will be also useful and they will respond to all the challenges and questions that we are facing today. Thank you very much indeed. Thank you very much. And now, Anna Huk will take the floor. She's the member of the board of the Podkarpackie region, and the floor is yours, madam.
Szanowni Państwo,
Ladies and gentlemen, it is my great pleasure to participate in such an important event today. I have a pleasure to represent the management board of the Podkarpackie region today, and I would like to convey our best wishes, the best wishes from the Marshal of the Podkarpackie region and all the other members of the management board. I am very pleased that the management board of the Podkarpackie region is the main partner of this event. Ladies and gentlemen, there are many partners here and patrons. One of the ministers has already been mentioned, the Minister of Education and Science, the Ministry of Family and Social Policy, the Minister of Justice, the Voivod of the Podkarpackie region, and the Mayor of the city of Rzeszów. So we can see that the subject matter is of great importance, and many local governments, ministers, institutions are very much interested in the topic of your debate. I believe today's world, looking at the time of the pandemic, COVID-19 has been changing. And has been changing tremendously, and conditions of work have changed. So these new conditions have to be discussed and analyzed. There are also various changes in the rules of procedure, legal regulations, so all the provisions which regulate cooperation between an employee and an employer. I believe that many topics which will be discussed today, also in terms of introduction of innovations, how to meet all the challenges like hybrid work, distant work, telework. These are new challenges to us, and I believe today's conference will open up new topics to new topics that perhaps will be taken up during the next edition, the third edition of the conference. I hope you will have a fruitful debate and you will come up with various conclusions, many academic, scientific conclusions, but also practical conclusions, and I hope later on they will be translated into our everyday activities in the labor market. Thank you. Ladies and gentlemen, we also have Barbara Kiełt, the District Inspector of Labour. Welcome. Rector, Madam Dean, Director, ladies and gentlemen. It is a great honor to welcome once again on behalf of the organizers. So the organizers is the Department of Legal Sciences and Social Insurance at the University of Rzeszów, as well as the similar institute of the Polish Academy of Sciences and the Institute of Labor Law and Social Policy. So welcome to all of you to Rzeszów. Welcome to those of you who decided to visit us in person in the capital city of the Podkarpacie region. And let me also welcome our distant participants, online participants. So it is a great honor because we can host eminent representatives of the academia from Poland and abroad. European universities, non-European universities, and practitioners. So we are opening the second edition of an international conference organized in Rzeszów. This time it is entitled The Concept of Employee and Employer, among many platforms which will be discussed. We can say that what is topical is an attempt to answer the question about the need to redefine the concept of employee and employer, the dynamics of changes and flexibility of the labor markets, problems connected with the pandemic, development of new technologies, justify the need for in-depth debate and the necessity to explore once again the definitions of the above notions. Undoubtedly, during the conference, we can't answer all the topical questions, but our debate, I hope, will be a contribution to further analyses, which will be then translated into academic papers. The labor law is facing a huge challenge once again. We can see that because we can notice so many topics of the papers you have proposed. So we are very glad that the debate is taking place at the University of Rzeszów, which is the youngest among Polish universities that's celebrated its 20th anniversary in September. So here I'd like to say something kind and full of gratitude to all of you who decided to prepare their presentations. I hope it is not our last meeting in Rzeszów. I hope we'll be able to host you once again, all of you in person, preferably next time. Now, I'd like to say thank you to all the organizers from our institute, especially Dr. Agata Ludera-Ruszel and Michał Skóra. A big thank you to them and a big tribute. Many thanks for the whole effort in organizing the conference. And I'd like to wish to all of us that our exchange of ideas and concepts is carried out in the best possible atmosphere. I can convince you that we as hosts will do whatever we can to organize the best possible atmosphere, so warm welcome to all of you. Ladies and gentlemen, the second edition of the conference is taking place in a hybrid model for the first time, perhaps for the last time. And this time we are going to have 46 speakers, 16 of them represent foreign university centers in Germany, Italy, Spain, United States, Ukraine, Taiwan, India, Portugal, and Romania. It is our pleasure to say that our conference is taking place thanks to the support from the university, from the Ministry of Education. The main partner is the Podkarpacie region, and we received financial support from the European Fund for Regional Development. This conference is possible thanks to financial support from the plant in Ropczyce, Magnezyty Foundation. So we have the following patrons: the Minister of Education, the Ministry of Family and Social Policy, the Minister of Justice, the Marshal of the Podkarpacie region, the Mayor of the City of Rzeszów, the State Labor Inspection, and Director of the University of Rzeszów. There are also media patrons. Channel 3, Polish TV, Gospodarka Podkarpacka Portal, Monitor of Labor Law. So many thanks for your trust and support. Ladies and gentlemen, as the head of the organizational committee, I'd like to say thank you for your involvement in organizing the conference. So many thanks to my colleagues from our institute, and many thanks to all the students and PhD students, also students from the Technical University of Rzeszów. Ladies and gentlemen, I'd like to wish to all of you that we have a courage to formulate interesting theses which will be inspiring, that we will be able to think out of the box. I hope you will have a fruitful debate and will be inspired to our further work. Thank you very much indeed.
Dziękujemy bardzo serdecznie pani doktor. Proszę państwa.
Many thanks, ladies and gentlemen. There will be a very short break and then we'll move on to the first plenary panel. So, speakers, yes, please take your seats and we'll begin our session in a second.
One more minute. Dear all, with this I'm opening the first plenary session, and we have 2 hours for that. And my big request goes to the speakers. May you please observe the time constraints, and with that allow us time for discussion. So our first speaker is Professor Antonio Aloisi from Madrid University, and this is a remote connection.
And I will be more than happy to add some slides for communicating my key insights.
Recording in progress.
Okay, you should be able to see my slides. Let me know. Thank you very much again. It's a pleasure. I want to thank all the organizers, and in particular, Professor Agata Ludera. It's a wonderful opportunity for me to present the preliminary findings of my current research project, which is the Marie Curie project titled BOSS Ex Machina. The goal of this project is to map and understand the digital transformation of managerial prerogatives in workplaces that are driven by machines, algorithms, and online platforms. This is the outline of the presentation. I designed this exploration of several issues that I would like to put together. I will start by trying to propose to overcome the misclassification dilemma. We have been discussing so far about the legal boundaries of the employment relationship, but I will argue that this is a narrow approach, and I will try to stress not necessarily the presumed end of employment, but more importantly, the goals of the employment relationship. I will also propose an alternative research hypothesis, which is based on the hypothesis that power has been augmented by technology, and then I will try to test, to assess the resilience, the resistance of the existing legal framework. I will conclude with a modest proposal on the role of technology when it comes to empowering and emancipating your environment, which is based on autonomy. This is the recipe for upholding innovation, in my view. Now, in this slide, you can see an overview of the most important cases that have been decided so far in several jurisdictions across Europe and the UK. As you may be aware, the solution is somehow a patchwork of different judgments and rulings. They are fact-dependent. Results are somehow unpredictable, if not erratic. Platforms, however, are employed in several lawsuits all over Europe. increasingly, higher courts, Supreme Courts, have recognized the existence of an employment relationship. Workers have won before courts. At the local level, several lower courts are still basically claiming that workers are not employees. At the same time, thanks to this intense litigation phase, we have developed an adaptable notion of subordination, demonstrating that existing legal categories are suitable enough to accommodate an emerging reality. The notion of subordination has been basically redefined and refined based on the notion of algorithmic control, of the flexibility in allocating tasks or in selecting the shift, the flexibility or the lack thereof, the ownership of assets, and the entrepreneurial risk. Now, even if this is a promising development, I would like to argue that this external perspective on the legal determinants of the employment relationship, is not sufficient, is not enough, for at least three main reasons. The first one is that, as we know, in terms of effect, the answer to the dilemma has a limited scope. It is crucial only for the parties that are involved in the legal proceedings. All the more so as platforms are tweaking their terms to circumvent the outcome of the most important litigations in countries such as the UK, Spain, and Italy. At the same time, we are witnessing a shift in the object of contestation by workers. They are starting to basically claim their rights in terms of anti-discrimination, anti-union conduct, and of course, algorithmic management. So instead of discussing about the boundaries, which is of course a remarkable exploration for labor lawyers, we should probably change our perspective, not necessarily to consider the notion of employer, which is even more puzzling, but to look at the key functions of the employer and to understand whether power dynamics have been reconfigured by technology at the workplace. I would like to sketch out very briefly the proposal that I would like to develop. Very often we have been discussing about the goal of labor regulation. Now, it is commonly presented as a tool to protect the weaker party in a relationship, but labor regulation is much more than workers' protection. It is about assigning and then constitutionalizing, humanizing, rationalizing the managerial prerogatives that labor lawyers unpack into three main powers. The powers to organize the production by issuing orders and instructions, the power to survey, to monitor, and to assess the compliance with the issued orders, and even the power to punish, to sanction recalcitrant workers or poor performer. Now, this structure, this vertical hierarchical structure has been crucial for the development of the modern enterprise. What is happening at the moment is that there is a decoupling, a delinking between obligations and protection. This decoupling is happening from the wrong side, according to my analysis. Not on the side of protections, but on the side of obligation and constraints or for workers. So at the same time, the legal position of subordination is under attack due to the widespread recourse to misclassification, but its main features are spilling beyond the realm of employment. So a question worth asking is the following. Is authority today the same as authority in the past? And how should the legal and social institution act, react, or adapt to this condition of total wiring in the workplace where command and control positions are spreading regardless of the contractual classification? And I would like to present very briefly the current evolution in the role of algorithms at work. Now, very often we've been bombarded about these presumed hypotheses of the workless society. Robots, machines, and algorithms are here to steal our job. This is a false narrative. At the moment, modern technologies have a twofold function. They are both potentiating the role of decision taker and distancing them from the decision, thus diluting responsibility and confounding all liabilities. Power augmentation, I'm well aware, is less attention grabbing than full automation. Full automation can occupy the cover of newspapers, and this basically makes gaps in production system and loopholes even more palpable. I would like to discuss a bit the transformation in the potential of algorithms and modern technologies. In the past, algorithms and AI have been primarily used to describe the behaviors at the workplace. Algorithms were nothing more than the digital representation of numbers and statistics used to portray reality. Then algorithms have become more powerful. They have been used to infer, to foresee and predict thanks to correlations. On the basis of patterns, algorithms have been used to predict future developments, team dynamics at the workplace. What is happening at the moment, and this is a legal challenge for labor lawyers all over the world, is that algorithms are being used to prescribe behaviors. They are reconfiguring the interactions at the workplace by manipulating the behaviors. They define an horizons of possibility, and as a result, the autonomy, the agency, the freedom of workers is very limited because of this use of technology. Workers in many contexts are witnessing a shift from direct observation to technocratic control. The power of bosses have been magnified, and the pandemic has been the perfect storm in the development of surveillance technology, for instance. And all workers, both employees and self-employed ones, are exposed to a form of omnipresent real-time organization and surveillance, which is not confined to the workplace and to working time. What is problematic, what is exerting a pressure on legal institution is that this augmentation is not matched by the counterweights that are defined by the legislature or collectively negotiated by social partners. So very briefly, now it's time to provide a conclusion by assessing the legal framework. If we consider this genetic mutation of managerial prerogative, this transformation in terms of informational asymmetry in the full cycle of employer prerogatives, from hiring to firing, we may easily understand that the EU legal framework is not well equipped to address this transformation. The legal framework is meant to constrain the role of managers to avoid the excesses of power. And central to this framework is the concern with causation. Now, causation cannot be detected in an algorithmic world because AI mainly operates by means of correlation, not causation. An existing provision which are mainly based on an analogical understanding of technology, may fall short in providing an up-to-date model. I have provided here just two or three examples to present the most problematic and nefarious challenges. The canonical limits to the power of employers have been conceived in a time when the potential of new techniques was even unthinkable. Power was exercised in a human, direct way. I'm well aware that that have been always designed as a chain of command. Power have been exercised by delegating authority to managers, but these challenges are to a certain extent novel. So how is it possible to tame algorithmic bosses when decisions are taken by automated decision-making system, or when, for instance, inferential analytics is able to cluster workers together and to discriminate by correlation, not even by proxy? The EU legal framework is somehow narrow. It is based on protected characteristics. It is able to address the discrimination by proxy, but nothing has been tested in terms of discrimination by correlation. The same can be said for the disempowerment of co-determination rules and procedures when, for instance, surreptitious technologies are adopted. I'm referring to the so-called panopticon that was developed during the pandemic to check on, to spy on remote workers, for instance. And then what about the efficacy of dismissal law when bogus self-employment are basically fired simply by discontinuing them? The final point that I would like to offer is a rather important concern about the wasted opportunity. Technology was meant to free our energies and our potential. Instead of facilitating and emancipating new environments at the moment, at the workplace, technology is often used to deepen hierarchy and control over worker performance, team dynamics, usage habits, social behavior, and even sensitive characteristic. And this is my final point. The boss-worker pyramid, which is embedded in vertical centralized organization, is now spreading all over the labor market, regardless of legal classifications and even without the entitlements compensating the lack of agency that are enshrined in the employment relationship. So we should somehow rediscover the potential of technology in promoting autonomy and not necessarily automation or augmentation. Now I'm proposing 3 alternative pathways that have been already explored by workers, also by means of the so-called strategic litigation, that is, promoting challenges, legal challenges, in order to open new avenues for contestation. Increasingly, not only platform workers, but a large number of workers are trying to challenge algorithmic bosses by relying on Article 22 of the General Data Protection Regulation, which basically provides for a ban on automated decision, including profiling that have significant legal effects. There is an exception involving employment, but even if when automated decision-making is exercised in the context of an employment relationship, safeguards have to be put in place and all the GDPR principles have to be respected and complied with. Then another strategy has been premised upon discrimination law, challenging the cruelty or the blindness of algorithms that are not able to distinguish between the reasons for an absence from work. In countries such as Italy, for instance, a judge ruled that an algorithm used by Deliveroo was discriminatory because was punishing workers that were absent for enjoying a constitutional protected right to go to strike. And then health and safety is another alternative strategy that can be mobilized. For instance, during the pandemic in the UK, in Italy, workers, also self-employed workers, were able to obtain the recognition to the right of being provided personal protective equipments. This has resulted in an expansion of the scope of application of health and safety regulation in several countries, a situation that is in line with the position taken by the Court of Justice of the European Union. So, here, I would like to advocate the importance of human bosses. Human flexibility is always blamed for being a source of biases and injustice. At the same time, many machine learning experts are claiming that human bosses have discretion, judgment, and agency. These values are crucial when it comes to overcoming the inevitable imperfection at the workplace. Human bosses, I'm well aware, are far from perfect. At the workplace, there could be a situation of abuse of power, but when it comes to the legal framework, modern legal systems have already developed practices in confronting the shortcomings in human decision making. On the contrary, we should basically readapt all these techniques and remedies because at the moment, technology coded authority is far less flexible and open-minded. Basically, algorithms are trained to develop capabilities on the basis of existing granular data, and these may ends up perpetuating biases and disparities that are stratified in a wealth of information. Now, disruptions is not a wonderful value in an already broken economy and problematic societal context. We should use technology to improve the precondition of society. And we should also use technology to promote an autonomy supportive context where human judgment, creativity, diversity is promoted. Only autonomy can uphold innovation, can be a positive vehicle of success, productivity, and in the long run, it can also foster relatedness, commitment, and productivity. I will stop here, and I want to say thank you for your attention. It has been a wonderful opportunity, and I'm very happy to be here and to discuss the key elements, the key insights that I've shared with you. I look forward to your comments and requests for clarification. Thank you very much.
Dziękujemy bardzo serdecznie panu profesorowi. Bardzo
Thank you very much, Professor. Now it's time for the next speaker. It will be Professor Ludwik Florek.
Szanowni Państwo, drodzy przyjaciele.
Ladies and gentlemen, dear friends, I'd like to thank you for inviting me to participate in the conference. It is my great pleasure to come to Rzeszów. Many thanks to the organizers for their efforts. And there is a great atmosphere, I can already feel that. I guess it is due to the hospitality of our organizers. So the topic of my presentation will be an employee as a party to the employment relationship. I can justify this choice in several ways. The first justification is that the notion of employee is the central notion in labor law, and the whole development of labor law revolves around protection of an employee. Even if we have some other organizational elements, still the most important thing is protection of the employee. And another justification is that changes in the labor markets and changes in forms of employment are combined with the following. When they appear, there is a question. Is it going to be employment as such or a different form of a work relation? There are different answers to this question, but there is a possibility to apply certain elements of labor law to even atypical forms of employment, because we can give a full status of employee, the Court of California considered remote work or telework as a form of regular employment, or sometimes only certain elements of employment relationship are taken into account. It happened in the case of contracts, which were civil law contracts, and basically that's a structure which has been solidified. It is attractive from a social perspective of employees and the society, because the society knows that we have to protect the employees because they contribute to prosperity of a given society. What else? Let me also point out another aspect. The International Labour Organization, which carried out a research of legal frameworks of employment relationship, it was like 15 or 16 years ago, when they prepared certain recommendations on employment relationship, and in their final report they said that employment relationship is still an attractive form of employment, not only in developing countries where employment is very often taking weird shapes, actually not really we don't really know on what legal forms they are based, but in developed countries as well. So if we talk about the employee as a party to the employment relationship, we have to say first that it is a physical person. I need to say it first. It is a physical person, which means a person, a human being. So let me just say that no one is born an employee. Sometimes we say he is a born director or he's a born manager, a born boss, but it is just a colloquial statement. It is not connected with any legal qualification. The legal qualification is taking place when an employee concludes an employment contract. So employment relationship begins. So it is of topical interest to us. So first of all, if we say that it is a person, it means things happen personally. This personal aspect appears at the beginning of employment relationship, and then throughout the employment relationship. You can't do it through third party or through a proxy or through a representative of a candidate for employee. No, they cannot conclude an employment relationship. It has to be done personally by the person. Then providing work has to be done personally. Well, there are some exceptions. There is the Code of Obligation of 1933. In case of some emergencies, one employee may use support and help of another person, even if this other person is not an employee. Well, so it is possible, but there were attempts in the 1990s that it was considered that you may have the civil law contract approach, even if a person does not do work personally. No, I don't think it is possible. I do not agree with such a solution. All right, so this person has to have a capacity for civil law relations, but I'm not going to talk about that. The definition of employment relationship by International Labour Organization, I refer to ILO not by chance, because there is a definition by the European Union. There are various definitions in international legal acts, but ILO is a team of many people who work on terminology as well, on definitions as well. So it is well grounded, it is checked, it is tested. I spent 1 year in Geneva, and I listened to the discussions about the representatives of ILO with representatives of British, American, and French academia and various institutions. So when there is a notion mentioned by ILO, it is applied and tested in many countries. So now we say that a person becomes an employee after starting employment relationship, and actually that's the second step, because the first step, as we can see from various definitions, and not only ILO definitions, but also national definitions, mostly the German, Austrian laws, emphasize it very strongly in one sentence in textbooks, but employment relations depends on concluding an employment contract. So there are 2 levels and 2 steps there. First, there is conclusion of the contract, and then the law qualifies that. Well, it is a certain simplification, but if the employment contract is in paper, it is a document you can keep in hand, but an employment relationship is a legal relation. It exists, but we cannot see it. It is not material, but the law is, the rule is that when the contract is concluded, employment relationship is started, but sometimes an employment contract may happen previously or it may happen later on. But the second case is rare. I will discuss it at length later. An employment contract, like an Article 26 of the Labour Code, is previous if we have the situation that parties conclude their contracts and postpone doing the work by the employee. When an employee starts doing the work, it is the moment when employment relationship is created and is beginning. There were different theories in the past which made an attempt to limit the significance of an employment contract. But there are bad associations with theories because they were created in the Soviet Union, in Germany under Hitler. So now we forget about these theories and employment relationship is defined differently. There are various options actually, but I'm not going to discuss all of them. There are certain backlogs and certain theories that we can refer to. But, well, our codification committee, in which we participated with my friends, Professor Vratny sitting next to me, wanted to simplify certain approaches and certain notions, but unfortunately it was put on shelf and we were unable to simplify it. We had an employment contract, and let's say that starting employment relationship is postponed. The question is, what is happening then? The situation is not fully clear. Undoubtedly, there is an obligation relationship because an employee obliges himself or herself to do some kind of work, specified work, generally specified work. An employer obliges himself or herself to pay for the work. So this contract needs to take place because we have at least three elements that cannot be deducted from the labor law regulations, because other things can be simply deducted from or deduced, from the labor law. So definition of obligations connected with a given job, the date of starting work, and there is the third aspect, and the speaker says that he has forgotten the third aspect connected with the date of beginning work, but it doesn't matter that much here. So if we have these three elements, they have to take place. And if there are two steps, like signing the contract and beginning the employment relationship, we are waiting for the moment of starting work. Regulations do not talk about it specifically. They just say that the moment comes that the person who concluded the contract should start their work. Additionally, it is justified by the fact that it is very simple. For an employee, it is simple. It says in the contract, your work begins then. If the vocabulary is too complex in the contract, it might be misleading for an employer. Here you have a specific date and it becomes clear. The question is, what is happening in the meantime? Whether the contract is still valid? Yes, but not fully, because if there is no work per se, a big part of the labor law is not functioning yet. But as I see it, other elements are already in place if they are connected with concluding the contract. So there are some interests on the side of the employee and employer which require that some consequences are taken from the concluded contract. Obligation of taking care of interests of parties. If someone signs the contract, this person, for example, needs to follow secrecy, confidentiality, and they should not do any competitive activity. And there are similar aspects included in the intermediate periods. And then one more thing, which is very weakly discussed in the trade press, even though it is a very interesting aspect. Let me just say that in other countries, there are broader analyses of the topic. I know that such analyses and papers are produced in Spain because I'm a student, after Erasmus stay in Spain, came back to Poland with the topic of a situation of employee in the context of starting work versus criminality. So we can see that in Spain it is discussed. And we say that before employment relationship or before concluding the contract or after concluding the contract, there are certain additional elements preparing the employment relationship. Obviously, they are connected with health and safety, so training on health and safety. There might be other aspects, like controlling qualifications. It is not only about education declared on CV, or that after looking at CV, employer says, well, your university studies are very exotic and eccentric. No one has heard about your university. You promised us a prestigious university and it doesn't seem so prestigious. No, that's not the point. The point is that in the meantime, you are checking whether there are no legal obstacles against starting work or against employment. There might be some legal obstacles because in certain jobs some certificates are required or other permits, consents from some administrative institutions, and so on and so forth. So in such a situation, I would say despite concluding the contract of employment relationship may not start. But because legal regulations are not very specific there, it seems that we apply very general rules. If there is duration of employment relationship, it appears not only towards the end of employment, but I guess it appears also at the beginning. So if we concluded the contract, and we say in legal regulations of the labor code about notification or termination, we have to apply all these legal provisions, because there are no other legal provisions. Definitely we could not say that the contract is terminated or expired, because if we say it expired, it requires a legal foundation. There are different provisions here. One says expiry of the contract, expiry of the employment relationship, and the other case is connected with the death of employee of employer. And another issue connected with that is hiding employment. It appears in two forms. Number one, I will discuss it further because, well, something was concluded in the first case. It seems it was a contract, but it is not revealed. The conditions of the contract has to be prepared on paper and presented to the employee before starting work by the employee. So it seems clear, but we don't know whether there is a contract because it is hidden. The employer did not reveal anything yet. It may be a different foundation, different basis for employment, not the contract. When the labor inspection interferes, they qualify it too roughly. If it is hidden, mostly employment contracts are hidden because there are, well, clear sanctions, civil law sanctions. So it all depends on the form. And I have a reflection here. When the legislator was thinking about that, it was about catching employer hiding employment. How it will be qualified, it doesn't really matter. So it is Article 26, and it means that this contract had to appear somehow. If we say that conditions are revealed, if there are conditions, there is a contract. I guess it is concluded on such a basis that there is an assumption that the contract was concluded. How was it assumed? Well, it is forgotten that, well, it was a very fashionable thing in the pre-war period, just after the Second World War. With Dr. Ruschel, we talked about that. We have similar opinions on that. What I mean here is that we don't want to go to the fact there are three ways of concluding the contract: in writing, orally, and implicit. And if we say explicitly, if the contract was concluded orally or implicitly, it is also the contract. You just have to confirm it in writing, then it would be clearer. If we don't have a clear contract in writing and we want revealing the conditions, this contract has to be somewhere, has to be recreated somewhere. Well, as I'm saying, people are not paying too much attention to that right now. And then there are like side effects, like violation of the duty of notification to the social insurance. And there are obligations towards tax office. In a state of rule of law, we have to support the fact that the authorities want to have premiums and taxes paid, undoubtedly. I'm not going to discuss it because I'm not an expert. People are saying, all right, they may waste my taxes, I'm not going to pay. No, that's just a digression. It is not the topic of my analysis. So if a person who wants to be employed, and if an employer is in place, they have certain obligations towards social insurance office and tax office, and these duties have to be performed, and we have to support it. There might be obligations, and there are obligations, they have to be fulfilled. I have doubts, however, whether we can do it bypassing the labor law. That we neglect the labor law provisions, but we decide that it is an apparent employment because someone was notified to the social insurance office and this person is not performing any work, just waiting for a maternity benefit or old age pension perhaps. Maybe not now, but in the past it was happening quite often that there was like fictitious employment, like an administrator of a building, something like that. It was just fictitious. It was fake. It was fictitious employment. We have to fight that. It cannot happen. It is not legal. But Social Insurance Office has a dominant role here, and the Supreme Court doesn't really know what to do about that because it considers such apparent employment and apparent employment. That's what I'm saying. So it is not connected with the right to any benefits. Only after apparent employment turns into real employment, a person is entitled to various remunerations, benefits, and so on and so forth. Okay, I'm about to wrap it up. So I'm referring to Article 22 of the labor law now. And I want to talk about starting employment relationship. So the parties conclude civil law contracts, and out of the initiative of employee or labor inspector, they may question the contract. The regulations facilitate our lives. There were so many amendments of Article 22, but now there is something simplifying qualifications of that. It says that a civil law contract is an employment contract if it fulfills all these aspects I've already mentioned. So it is clearly an employment contract. There is one difficult situation, namely the parties conclude the contract, then performing work is like that. Well, we can say, yes, there is employment relationship, but the parties agreed to conclude the contract, so there is this freedom of parties to conclude the contract. It is Article 11, Article 2012. They overlap to some extent. There was a clear will of both parties and also the factitious position of the parties. It is difficult to assume that someone forced the other party to conclude the contract, like employer forced the other party to conclude the contract. Very often both parties are interested in concluding the contract, and the Supreme Court emphasized that well, the borders of the statement are quite blurred, but here we have to be simply quite cautious. Courts have the following approach. They are quite cautious, but some judges complain. I remember a case that a labor inspector took the matter to court, that 3 civil law employments should be considered employment contracts. There were 3 interested parties, 3 persons, and they said they want to still have civil law contracts. The court was quite supportive. There are these elements I've mentioned. We can see there is factual employment. There was no enforcement of anybody's will on anyone else. And there was the last trial. And the judge said, one of ladies stood up and she said, I want to have an employment contract. Why? Because I am pregnant, she said. So the case was very clear. It shows that these lines are blurred. Goodwill of parties is also, well, not very clear sometimes. So we cannot dismantle the mechanism from Article 22, but we simply have to be cautious. I do not reveal any secret if I say, because the invitations were sent to many people, that the labor inspection held a conference in the subtext, they wanted to increase the limits of authorization of the labor inspection, not to take so many cases to court. But in my opinion, I guess it is fine as it is. I wouldn't tamper with the authority of labor inspectors. I wouldn't increase their competences. I guess I would remain to the current solutions. If we can establish that there is employment relationship, we can just say that employment relationship lasted since the very beginning, unless they prove that, first of all, it was like contract for a specific piece of work, and only after a period of time it became an employment contract. But usually all the time it is the same kind of employment, quite simple. So if we prove that, obligation of employer is very big. Employer takes some risks because there might be an accident at work. Well, so there are some obligations in the light of the labor law on the part of employer. The last thing I wanted to say, well, I want to mention the most eminent representative, the person who is Professor Wacław Schubert, our guiding light. He always emphasized that employment relationship has many meanings. There is not only economic significance. Obviously, a person receives remuneration and the other party has some benefits, but there is also social significance of employment relationship. There are several aspects of social significance of employment relationship. First of all, it is a source of people can live off it, and there are families then. Then there are some insurance benefits. Thirdly, very frequently employment gives us various advantages like higher qualifications and ability to function within a team, many other things. Obviously, in senior positions, you receive various privileges like a golden package, business trips, travels abroad. But as Schubert emphasized it, employment in our conditions, it was actually written in the previous era, so under the socialist Poland, but Professor Schubert said that employment in our conditions is then translated into the social position of a given person in the society, also in their circle of friends. Obviously, things have changed under the pandemic, and our friendships, our social relations were weakened, but employment contract employment is very significant for the economic aspect, for the social aspect. It guarantees us so many things, so I guess I'm going to wrap it up here. Thank you very much for your attention. Thank you very much indeed. It was Professor Ludwik Florek. And now the next speaker will be Professor Mirosław Włodarczyk. Professor Włodarczyk is our online speaker. I guess he's connecting with us from Łódź.
Thank you. Thank you and good morning, ladies and gentlemen. I hope that you can hear me and see me well. I would like to thank the organizers for inviting me to take part in this conference. And I also apologize for my speaking to you remotely, but unfortunately I am unable to attend the conference in person. So I'll be speaking about employer and employee. These are categories and notions which at present are broadly discussed, and when listening to these discussions and when studying labor law, I've come up with certain observations that I would like to share with you. And these observations relate to the protective function of labor law. And I think that Professor Florek's closing remarks on the social importance of employment and social importance of work would be a perfect bridge leading to my presentation. So I'll be talking about employee and employer in the light of the primary paradigm of labor law. So we're talking about aspects that resulted from current developments in our environment. I believe that they should be also analyzed in a historical concept and through historical experience. This is why I speak about this primary or original paradigm of labor law. My definition of a paradigm is that this is a way or a method of seeing the reality. These may be a set of categories of concepts. There may be many categories, and they are a reference point for analyzing reality. This is how I see it. Now, moving on to the essence of my presentation, note that first, labor law was originated from the need of persons working for other entities. Initially, the law was to offer tools, measures, ways to satisfy their social needs, the needs of their families and their needs. So it was about ensuring certain level of remuneration sufficient for self-sustaining, protection of those most exposed to the burden of employment, protection of children and women in childbirth and mothers with young children, then prevention of work accidents and protection of victims of such work, of persons who suffered such accidents. So at the onset of the capitalist era, the work time was practically unlimited, and law evolved towards reducing the work time to allow for regeneration, but also to expand or extend the lifespan and the duration of a professional career. With that, legal regulations, which now form labor law, have been developed. With the emergence of trade unions, of labor unions, the scope and intensity of the regulation have accelerated. Initially, labor law was not focused on one specific type of employment. With time, employment relation or employment contract was promoted to the position of the main type of work or employment relation. And the difference between employment contract and other work relations was manifested itself mostly by the category of subordination. And I believe that the category that was emphasized was the category of subordinated work. In practice, with time, that attachment, overreaching attachment to employment contract or work contract evolved, and in simple terms, we may risk a statement that employees were protected by labor law. Non-employees, persons other than employees working on the basis of employment contract, were not protected by labor law. For this reason, that subordination to labor law is often considered the paradigm, and these are the building blocks of labor law. In the end of the 19th century and in the early 20th century, but also later on in the entire 20th century, that type of relation was very useful. It was a very useful simplification of relations. An employee was joining that protected group. Non-employees did not enjoy any protection, and that simplified things for everyone. And in mid 20th century, growing cost of employee protection in labor law caused employers to prompted employers towards attempts to evade costs of employment, and the phenomenon of globalized production and globalization supported and facilitated the process. So business entities, large and rich corporations, were trying to achieve and were delivering their business objectives in countries without developed labor protection in their native countries. With high costs of labor protections, solutions were sought to avoid high employment costs, and these solutions included some complicated organizational structures, various forms of employment structures such as holdings, dispersed or fragmented holding groups, popularity of term contracts, temp work concepts. It all served to reduction of cost and evasion of employee-employer relationship. These phenomena accelerated exponentially over the past 10 to 20 years with employment or hiring staff through platforms and through a variety of work relations without offering any additional protection. So these are contracts for specific tasks. These are contracts for on the B2B basis, and some other complex types of employment relations. And that results in a growing pauperization, in growing impoverishment of persons who are not protected by labor law. So such a labor relation is no longer beneficial to persons working to other for the benefit of other entities. And well, the fourth thing is that persons working for the sake of other entities should enjoy social protection. That goes without saying. That is beyond any debate. The period of the pandemic caused helped us to participate in many meetings in Poland and abroad, and we can see that there are numerous debates, and these debates are quite lively. So persons working on a basis of contracts other than employment contracts, they should also enjoy protection. The important thing is to set the criteria that would define eligibility for such protection. In other words, eligibility for demanding such protection. In my opinion, it is not necessary to find a new criterion, as many say or argue. In my opinion, we should more refer to the origin of the labor law. Initially, for practical reasons, such protection offered by labor law would extend onto any person who had to work in person for an entity. And that was the definition that prevailed over the first decades of labor law existence. The type of labor relation was not decisive in this context because, as I mentioned, that came later as a category well rooted in the field. But now an attempt to refer to the criteria as a contractual obligation to work in favor of a business entity would actually imply return to the primary paradigm, to the structure that ruled, prevailed, or determined development of labor law and decided about its role. To sum up, a provision of contractual work in favor of another entity should be decisive for a minimum wage, minimum salary, on the right of associate in labor unions. And then my fifth concept is, when referring to the criteria, note that this criteria is basically clear in the economic or social context. However, such clarity, such clarity of vision is not provided here when analyzing it again in terms of its historical context. So, for example, only an employee could enjoy labor protection under labor law. That was the only category that was approved by all parties involved, including trade unions, the state, employers and employee. So employment contract, work relations, that was broadly accepted. But in my opinion, nowadays the situation is very different, because employment contract is one of many options next to self-employment, contracts for provision of temporary work, or contracts for provision of specific tasks. And on top of that, it cannot be expected that entities operating on the market agree to resign of one of these available forms of operation. So we should be aware that in a way we're doomed to having these different forms of employment on the labor market. So self-employment, work contracts and B2B contracts will be options existing on the market. In my opinion, it will be no longer possible to create a uniform or homogeneous structure of an employee. There are such signals, there are such signs showing that we should be going more towards such uniform concept. In my opinion, the strive towards creating such uniform, homogeneous structure that resembled the one that we remember from the 19th century. The variety, the diversified types of contracts, that is the manifestation of differentiation of the labor law. And this is something which characterizes labor law. And then we have another important argument in this debate. Social partners and entities working on the market do not consent to all these categories of employees enjoying the same scope of rights and powers. So that is a crucial concept. It is now deliberated whether all such entities must enjoy the same rights. And my sixth observation is that we have another question that also undermines the entire concept. So the entity that finances the social costs, the entity that has liability and responsibility in the work relation changes. That used to be the employer, and that was a popular category. Apart from this work relation, I think it will be easier to determine entities who are partners in labor or work relation. So there is a question now, who is going to shoulder the cost of social protection in case of self-employment? Who is going to cover the cost of social protection when in case of employment through platforms or when on B2B type of employment? In particular, when platforms are the employer, what the paying or obliged entity is often hidden behind a platform, and the service is provided directly by the contractor to the client. So a person employed or hired by the platform and the customer, the client who requires the service. So the question is whether the service provider has a relationship with the end client or with the platform. So can we identify the employing entity? Can we define who's going to bear the cost of the social protection? So it's another concept here. Can we define who should be the party in the negotiations with trade unions about social protection? And my final concept is again the concept of the role of a state in these relations and responsibility of a state for the state of affairs. But that is the state, as I see it, that accepts the variety of business forms, and states accept different forms of employment. These forms of employment and business, they form an important part of the economy and of the labor market. The state, therefore, is not going to be interested in introducing bans or prohibitions in this area, like a ban on B2B relations or civil law contracts. So we're talking here about this unrightful replacement of contracts for work with civil law contracts for performance of a specific task. But then we have this self-employment category, and the state may not be willing to eliminate such category. So therefore, if such employment doesn't guarantee a minimum social protection to a worker, a question arises whether that should be the state that should be providing that social protection of such a worker, at least to the minimum level. So I'm asking about the state being responsible, at least partially, for social protection of such worker. And such approach of the state seems realistic in the light of the debate about the minimum guaranteed income. There are certain practices and some experiences in this respect. So this concept is now being implemented. So when it comes to the responsibility of the state, undoubtedly the role of the state should be included.
W tym kontekście, proszę Państwa, czy ten nowy pracodawca w świetle...
So summarizing the new employer in the light of the paradigm that I've already identified, that employer is not only the party to an employment contract, but an entity which is able and willing to co-finance social protection of an employee and the employee's family. If we talk about the distinguishing criterion, if we define it as a provision of work for the sake of another entity, so on the employer side, there is an entity obligated to offer, guarantee, and ensure social protection. It doesn't necessarily need to be one private or legal individual. There could be more than one entities. So what are my closing remarks and conclusions? They're as follows. I've formulated a number of questions. Unfortunately, not all of them can be answered right now. The debate continues, and what I was saying may help to analyze certain issues further. And my perception of this debate is that it leads to the conclusion that undoubtedly employees, people are employed outside a work relation, they deserve to have a social protection. However, there is no answer to the question about the party that should be offering that social protection. So that deserves to be analyzed further in consideration of the legal, economic, and social environment. I thank you very much. I hope I managed to fit into my time slot. I thank you very much for inviting me to this session and for offering me the opportunity to be with you, although remotely. And of course, I will accompany you throughout the entire conference. Thank you. Thank you very much, Professor.
Pana profesora Jerzy.
Now the next speaker will be Professor Jerzy Wratny.
Bardzo dziękuję, pani przewodnicząca.
Thank you very much, Madam Chair. Thank you very much for inviting me to the conference. I'd like to say that I feel in Rzeszów at home. I worked here for 16 years. This is definitely my place. Professor Kowalczyk was my assistant throughout this time. We had a great cooperation. Ladies and gentlemen, the topic of my presentation may seem quite exotic if you compare it with the topics of other papers, because I'm going to talk about the concept of employer and the concept of indirect employer in encyclical Laborem Exercens. It's been 40 years since St. John Paul II announced this encyclical focused on the issues related to labor. So we have an opportunity to share some reflections referring to some topics touched upon in the encyclical, connected with the subject matter of this conference. Encyclical is a diagnosis. It is also of normative nature, presenting Catholic ethics of labor, referring to contemporary issues. Obviously, contemporary here means 1980s. As part of social doctrine of the Church, it is also part of the section of theology called the theology of earthly reality. Laborem Exercens has many layers. As a document, we may notice the criterion according to which ethical information included in the encyclical can be divided into the ones pertaining to labor in a universal sense, and into those which pertain to specific systems of performing work. So they are evolving and they follow the changing reality. In this first approach, the key notion is the obligation of work in a moral sense. According to the intention of the Pope, the moral obligation of work has to be understood as a vocation to work, which is universal, experienced by all the people, so it is also found in every epoch. There is also a legal obligation of work in relationship between employer and employee. If we analyze ethical problems connected with the legal obligation to work, the author of the encyclical talks about universality of human labor, but also enters the field of historical social relations. His considerations and reflections focus on two fields: multi-layer approach to the notion of employer and rights of people of labor, so employees. These are key notions in the labor law as well. When we talk about employer, this side, what is of great interest, because it is commented many times, is differentiation between employer, like direct employer, and indirect employer. Direct employer, who is a party to the employment contract, well, it does not require an additional explanation, but indirect employer seems quite enigmatic. This notion includes all the implications and all the aspects connected with employment relationships at the level of indirect employers. Indirect employer is a state, especially in the countries with dominant collectivistic approach. At the moment, what is more significant are national or international capital organizations called corporations are the most significant. They have economic power at their disposal, exceeding the possibilities of some states. And according to the author of encyclical, they are responsible for deepening inequality in social and economic relations, both on a domestic scale and on a global scale. Indirect employer creates situation of implication of direct employers, makes it impossible, according to the Pope, shaping employment contracts according to the expectations of employees and requirements of justice. The counterbalance for negative phenomena originating from various practices applied by domestic or international corporations should be a moderating policy of the state and activity of international organizations. The encyclical tells us that it accepts the active role of the state in the economy, and it says that the market, to some extent, should be regulated. It is close to the ideal of what is called a social market economy, so it rejects a laissez-faire approach, so liberal approach. These ideas were formulated by John Paul II, Sollicitudo Rei Socialis, in 1987, developed all these ideas. In this encyclical, the Pope focused on the global dimension of social issues, criticizing the phases of contemporary globalism. In the context of his reflections over indirect employer, we should emphasize theological concept of structures of sin. The structures of sin described by the Pope refer to Vaticanum II, and it is the sum of negative phenomena whose impact goes in the opposite direction than the sense of real common good and the need to support the common good. The sources of structural sin are a cult of money and a cult of technology. As John Paul II emphasized, structures of sin are always rooted in a personal sin and connected with specific acts of people who perform the sins, strengthen these phenomena, and make it difficult for others to eradicate them. The remarks about the structures of sin are in line with criticism of negative phenomena, namely the role of some practices of indirect employers performed mostly by international corporations. I think that this concept of indirect employer corresponds with the lecture of Professor Włodarczyk, who was looking for employer for some forms of employment, saying that the state should interfere in certain cases instead of a different kind of an employer. In general, we can say that reflections upon employer by John Paul II focus on revealing the social context of employment relationship, especially by showing political and economic aspects. The vision of social relations in the contemporary world is ambiguous, but in describing these phenomena, there are more pessimistic notes. The sin rooted in the structures does not release anyone from personal moral obligation in making attempts to eradicate the sin. So there is ethical radicalism of the Church confronted with the contemporary world. And now in Laborem Exercens about employees. It refers to the rights of employees. Let us notice at the beginning that these rights, according to the encyclical, are correlated with an obligation of work. Even though in the encyclical it is said that there are obligations of work in many senses of the word, but the rights that we mention from their essence may be connected with the legal obligation to work. So obligations which are connected with certain conditions in employment contract. It is about employees' obligations in a classical sense of the word. For these reasons, the thesis in the encyclical has to be referred mostly to the field regulated by the labor law, or to be more specific, to axiology of this field of the law. When we talk about the rights of employees, we see that the Pope emphasizes that they are part of a broader context of basic human rights. So in other words, it is about social rights with the status of human rights. This status means that they result from inalienable dignity of a human being, so the primary foundation for these rights is the higher order, not only the law made by man. As the author of the encyclical writes, many of these rights have been proclaimed by specialized international institutions, and these rights are guaranteed by individual states. Contemporary collections of human rights from the labor law come from various roots of ideological inspiration. Some of them are leftist in their origin. We may also say that announcements of the Papal See, which started a Catholic social science, Rerum Novarum, by Leon XIII, 1891, were delayed. If you compare it with the need for the voice of the Church in the conditions of violation of employees' rights, especially in the 19th century capitalism of the industrial era. Axiological justification and the catalogues of employee rights presented nowadays are a general standard for our civilization. And like John Paul II, there are declarations and international laws, like the European Social Charter, with collections of human rights, and there it is mentioned that the international community recognizes their existence, but their roots are to be found in a higher order. There are some examples of such rights which are part of the standard, like the right to be employed, the right to have just remuneration, and so on and so forth. Civilizational heritage includes the rights considered to be part of the labor law, namely, it is the right to be associated in trade unions, including the the just strike doctrine mentioned by the Pope, participation in the life of a place of employment, so the right to participation. What is of special significance for employees is a problem of providing them with the right of participation in the affairs of their employment place. In the context of laborem exercens, the right to participation is not only a single right or simple authorization for employees, it is of key importance for the whole system of labor. In this context, the Pope refers to traditional theses of Catholic social science pertaining to ethical concept of ownership, burdened with social servitude. The right to ownership is not treated in an absolute way like in liberalism and the Roman law, but according to the social Catholic thought, a personal right to possession is supplemented by the rules of common use of goods and common application of goods. The social function of ownership allows to explain ethical relations between work and capital. In capitalistic relations, it seems to be the power which is conflicted with work. The key to solve this conflict is considering the role of primates of work, which is more important than capital. If we believe work is more important than capital, well, if we repeat it like a refrain, if it is a leading motive, if we emphasize it, we will consider it as a motive of progress. When we talk about participation, the Pope emphasizes the argument of personalization. According to this argument, a person who works wants not only remuneration, which is just and fair, but also taking into account in the process of production of such possibilities that this person has a sense that working in this place, they work for the collective and for himself. So it is also about a certain experience of participation in the process. Perhaps I should mention one more thing, namely indirect bodies. It is self-governing organizations like collective organizations combining work and capital, like cooperatives. The Pope believes it is very important that there are such solutions which are about participation of employees in management. For example, various options of participation of representatives, participation in shares, so financial participation, and shareholders being employees, and it is participation in the capital. Confrontation of the theses of the encyclical with Marxist doctrine is no longer very topical, but in the beginning of the 1990s in Poland and other countries of the former communist part of Europe, we had system transformation, which became a source of new threats, because we had wild capitalism, as we called it, and then it was assessed morally by the Pope John Paul II in his next encyclical from 1991. Perhaps now I should sum it up, and I should mention the social reception of the church doctrine in the Polish law, or to what extent the Polish law is in line with the Catholic social science. I'm not going to talk about details like the role of women in social life or fair remuneration. Let us focus on axiology. Catholic social science, as it's been mentioned, considers and supports employees' rights at the level of values expressed by them, pointing out that there is a certain hierarchy of these values and criticizes threats if these rights are violated, like an evil of unemployment. So Laborem Exercens focuses on that and focuses on rooting these rights in the dignity of an employee. In Polish legislation, the rights which are mentioned in encyclical are part of the Code of Basic Rules of Labor Law. The catalogue is not in contradiction with the church teaching, but doesn't show its reception either. To some extent, it reflects civilizational pattern taken by international organizations and European organizations, mostly the European Council and the European Union. So the best place expressing directly the main ideas of the social teaching of the Church, referring to the law, labor law and labor in general, should be a constitution, the constitution which is in place from 1997, actually in a correct way reflects the ideological sense of the social teaching of the Church. This impact is visible in the content of Article 20 about various rules of economic system of Poland, and in Article 24, according to which labor and work is protected by Poland. The second of these provisions is one of manifestations of considering that work is more important than capital. According to Article 20 of the Constitution, the pillars of capitalist economy, freedom of economic activity and private ownership are moderated by principles of solidarity, dialogue and cooperation of social partners. Such characteristics of social market economy in the light of encyclical is correct, but seems insufficient. According to the author of the encyclical, didn't only wanted to have a social peace in employment relationship. And it seems that the Constitution focuses on that, even though this goal is very much desired. Yet it is insufficient. According to a deeper understanding of common good, the focus of encyclical was placed on overcoming dichotomy between work and capital by socializing production values and production assets without undermining important features of capitalist economy. So it is about implementation of the idea of participation of every employee. So it is personalism, not only a collective body, but each individual employee. If we do that, we can say it is a real community of work. Here, the legal status and the practice of employment relationships are far away from the ideal presented in the encyclical. I should also mention preamble to the Constitution, which exposes basic categories of Catholic social teaching, like common goods, justice, or subsidiarity. The preamble to the Constitution sends a message, according to which axiology of the Constitution derives from Christianity, yet it is not of confessional nature, so it may or it should be shared by people who differ in their approach to the religion, but who have cultural, ethical sensitivity. The same may pertain to Christian teaching in general, like axiology of the system of work proposed by it. This teaching is rooted in the religion, and the encyclical, due to the status of documents like that, is considered to be part of theology, of earthly theology, but accepting that and implementing that is not conditioned by a religion or a view of the world upheld by a given person. That's all from me. Thank you very much for attention. Thank you. Thank you. It was Professor Wratny. It's been signaled that our presentations are too long. We have some time limits. I have a very difficult position here because I enjoy listening to your presentations because I'm listening to my professors, my masters, but it is my request now to stick to our time limits because our conference is of hybrid nature, so there might be some difficulties if we don't observe time limits. So please stick to your time limits. Now it's time for Professor Bolesław Ćwiertniak. He is our online participant. So the floor is yours, Professor.
Dzień dobry Państwu.
Well, good morning, ladies and gentlemen. Thank you so much for inviting me to this conference. I'm looking at the ladies and gentlemen on the panel. I'm looking at the composition of the panel that I participated in a few years ago, which was the first conference of the series. And I was with you then, ladies and gentlemen. I wish I could be with you in person. Well, but unfortunately, the National Health Fund somehow interfered with that, and this is why I have to connect with you remotely. To refer to as to the concept of this time discipline, and I would like to follow the concept here and present the key concepts of my presentation in a nutshell. Ladies and gentlemen, let me start by saying that the organizers were very right and had this excellent idea to go back to the foundation self-employment. Actually, it was more than it goes beyond my expression of the concepts here. So we're going here to the concepts that are based on the primary paradigm of employment relation. I enjoyed Professor Włodarczyk's work and contribution. So according to the organizers of the conference, that should be the subject matter of the debate. So it's about redefining concepts. About employer, employee, and the concept of labor and work relation. So we've already listened to contributions about diversity in comprehending these terms, and they also spoke about challenges that come with new technologies, including digital technologies, platforms, algorithms, and this is about social elements, social elements is mentioned by Professor Włodarczyk and other persons here. So also let me mention that, ladies and gentlemen, that we have that multitude of concepts, ideas and definitions about employer and employee as such. So because of this short time assigned to my presentation, and assuming that you already have certain knowledge on that, we generally have this idea of an employee. We have a conventional, autonomous, constitutional concept.
Referacie mówić. Kodeksowe mamy pojęcie pracy.
So we have this notion of an employee in a variety of secondary legislation and primary legislation, like law on group redundancies or act on trade unions, not to mention other concepts. And then we have a similar concept of an employer relating to the works of John Paul II. Professor Wratny, he mentioned that basic distinction that has been transformed to the labor law doctrine about direct and indirect employer. Not to mention certain notional mispresentation that I covered at the first conference of the series here in Rzeszów, when referring to certain concepts of Professor Maciej Święcicki. So I was saying that this is the person whom we call an employee gives work, is the employer, and the person who and then Professor Święcicki, he offered that concept that should be the contract giver, the work giver, and not an employer.
Tutaj zredefiniować te dwa elementarne.
So the question is how to redefine these two basic concepts. And here, let me refer to what I heard in the contribution made by Professor Włodarczyk, who talked to us from the city of Łódź. He pointed out that in his opinion, all the attempts to structure a universal definition of an employee are invalid. And why is that? So the question is about parties, about entities or actors or stakeholders, should be perhaps the parties here. So let me point to the fact that the concept of an employee and an employer is not a notion which exists independently. And these are elements of settlement of a legal work relation. So we have this legal work relation. So, we do that moving on to the redefinition of the work relation. In the abstract, I allowed myself the liberty to quote a very well-known poem by a Polish poet, Julian Tuwim. The title of the poem is either Residence, or it's well known as under the title These Horrible Townspeople. So, quote, these horrible people see everything separately. So it is my big request when attempting at redefining the concept of a work relation, or as done by Professor Florek when referring to the definitions occurring in international documents of work and labor organizations, or when referring to some specific concept, doctrinal concepts, scientific concepts. So it's about defining employees, employers as parties to a labor relation, to a work relation with some specific properties or characteristics. And Professor Florek talked a lot about contractual work relation. That could be an employment contract or contract for work. Therefore, we have this contractual work relation, but then we have non-contractual work relation. And then we have, as Professor Piątkowski said, and then quasi-real beings, concepts which are anchored in the text of labor code and in the text of other specific pieces of legislation. So we have a whole variety of employee types and employment types in the context of the work relation. And in particular, when it comes to non-contractual work, in particular, when we consider requirements towards candidates for work. So now about the content of work relation. In the theory of law, we have a variety of concepts here that tell us about the structure of work relation, from very simple and primitive to very complex. And here, I think we should be talking about the concept proposed by Professor Arthur Klein, who organized in order several and more than 10 different concepts here. So assuming that simple structure, for some the subject matter is equivalent to the content, and some consider the content a separate being altogether. And
bycie pracownikiem.
so how does that affect the concept of being a work provider, a worker, an employer, etc.? What's the impact of the relation on the person of an employee? And let me give you a very simple example. We have different ways of approaching a work relation. So that could be an elementary relation, or a core or basic relation, or then we have more complex approaches that name it a base relation. So Article 22 is like a concrete pillar on which other relations that accompany work relations are supported. Then we have work relation as a bundle of relationships. In theory of law, we tend to move away from a work relation in favor of a legal situation set out directly or indirectly. And I'm not going to go any deeper in that context. And then we have this excellent book by Professor Kubot on the legal position of parties to a legal relation. That was an attempt to reconcile these two options. And then depending on what is the subject matter of the work relation, we can define the parties to the work relation. And in the abstract, we have two simple examples. If we assume that the element of the content of the work relation are rights and duties regarding work safety and hygiene, then automatically the number of entities in the work relation is multiplied with many internal entities joining the because of the employer's concepts, and then we have the workplace. As Professor Sobczyk rightly mentioned, we too easily allowed the workplace notion to be removed from the labor code. Then we'll have the external entities, we'll have third parties.
Pracy wcześniej i tak dalej. Nie przedłużać, chciałbym zakończyć.
To cut it short, I would like to close my contribution with this call. If we define or perhaps redefine the notions of an employer, of an employee, we should also bear in mind that there is this concept of a work relation or labor relation, and there are various aspects and forms of such relation. We should bear in mind that there is this implied subject matter of the contract and the content of the relation. Also, let's bear in mind the types of the relation, and bear in mind that the notion of the concept of a work relation is one of the very many aggregate concepts of our labor law. And here, other speakers have already referred to these concepts when speaking about the key concepts of labor law. And then we spoke about labor law and its specific properties defined as characteristics, as determinants of the labor relation, as Professor Florek described it. It was about provision of work, etc. So I'll end here by saying that we should have this bird's eye view, comprehensive notion, and with these concepts, then we may have a whole variety of approaches, and I agree with Professor Włodarczyk.
Do pracownika trudno.
Difficult to consider seriously an artificially created concept of an employee or an employer. Thank you so much.
Dziękuję bardzo serdecznie panu profesorowi Bolesławowi Ćwiertniakowi.
Thank you very much, Professor Ćwiertniak. And I'm giving the floor to Professor Duraj.
Dziękuję bardzo.
Thank you very much. First of all, I would like to say thank you for inviting me here. I am glad I can deliver this paper, and I'd like to say congratulations to the organizers for excellent preparation of this event. It is my great pleasure because it is the first conference since 2019 in which I can participate on site. All previous events, especially last year, but also this year, were only happening online, and an online event does not reflect fully the atmosphere of conferences like that. Ladies and gentlemen, the subject matter of the conference is very well suited to the interests of the University of Łódź and our center exploring atypical forms of employment. We also work a lot and analyze a lot self-employment and various models of self-employment. And before I move on to the main part of my presentation, I'd like to invite you to Łódź. Unfortunately, online, we are organizing a conference in December, the 8th and the 9th of December, the fourth conference on atypical forms of employment. And we are going to focus mostly on a legal model of protection of self-employment in Poland, search for the optimum solutions and the optimum model of self-employment protection. Let me move on to the subject matter of my presentation. I am very glad I am part of the panel which focuses mostly on the concept of employee and employer. And I am also glad that I can be part of the panel which asks basic questions about the possible necessity to redefine the notions of employee and employer, because these notions are of fundamental significance for labor law. So the question about the necessity to redefine the concept of employee and employer is also part of a broader discussion about the future of the whole labor law, and possibly it refers to the need of development of the labor law towards employment law. So it will not only regulate a situation of employee and employer, but it will also include non-employment performers of work, so outside of employment relationship, but also self-employed will be included in its scope. I will focus mostly on people who are self-employed, but it is just a brief contribution to broader reflections on the future of the labor law. I would like to focus on two basic issues. First of all, I would like to think about whether it is the right time to discuss the necessity to redefine the concept of employee and employer. That's the first part of my presentation. Then
próbie odpowiedzi na to pytanie.
I will try to make an attempt and answer this question, whether redefining these concepts is really necessary, and whether we should change these concepts, and if the answer is yes, in which direction we should go.
Kwestie zasadności w ogóle
As for
postawienia tego pytania o
this
redefinicję
question,
pojęć pracownika
do we
i
need to
pracodawcy,
redefine the concepts of employee and employer?
jak najbardziej
Yes,
to jest dobry moment,
it is
abyśmy
the right
zaczęli
time to do
zastanawiać
that.
się
It is the right time to start thinking about that, to start asking this question, whether employee and employer should remain as they are in their scope that they've had so far, or perhaps we should modify them. Here, I would like to mention some contexts which clearly confirm that this question should be asked. In the labor law doctrine, it's been mentioned very often that a traditional model of employment relationship based on subordinated work paradigm is no longer useful. It doesn't suit the current relations of the labor market, so we need to redefine the concept of employee and employment and employer. Secondly, the question about redefinition of these concepts is connected with widespread usage of various forms of employment, also self-employment, and various atypical forms of employment. In the Polish reality, according to the data from 2019, a total number of people who work is 16 million in Poland. Out of that number, atypical forms of employment are 3 million people, and 1.5 are self-employed. So, it is a significant scale of non-employment forms of providing work. So we can see that the question we are asking is justified. Here, you have a slide showing the structure of atypical forms of employment, mostly fee-for-task contracts or self-employment. If we talk about the justification of the question, whether it should be asked right now, there is such a need to redefine the concepts, because let's think about international law standards. I know it will be discussed later on in other papers, but it is quite clear even now that in international law, the legislator assumes a very broad definition of employee in its protective provisions. So there are notions like workers or travailleur. It exceeds the scope of employee in a traditional sense, as an employee subordinated within the employment relationship. So protection in international law pertains to atypical forms of employment. I mentioned them here as well. So areas of protection exceeding this traditional paradigm of subordinated work. So health and safety, discrimination, protection of remuneration, social protection, the right to coalition, protection of families, protection of women, pregnant women, new mothers. So all these areas in international law are dedicated not only to traditional employees, but also pertain to non-employment contracts formulas. A discussion about the possible redefinition of employee and employee is also justified in the context of an analysis of Polish constitution, because many standards, including in our constitution, foresee protection which is guaranteed to non-employment forms. So it is not only employment relationship. Many regulations of the Constitution foresee a broad protection for people who are self-employed, or in a broader sense, for people performing work on other bases. Article 24, for example, which mentioned that work, in a very broad sense, is protected by the state of Poland, because we need to protect not only employees who are employed on the basis of employment relationship, but all the people performing work and providing services. So this broad approach pertains to health and safety rules, protection of health, discrimination or non-discrimination, and the right to coalition. As for the right to coalition, so to form trade unions, on the basis of this regulation of Article 24, the Constitutional Tribunal in 2015 formulated a notion of an employee in this constitutional sense, considering the issue of the right to coalition and to what extent it should be defined and to what extent it should be guaranteed. And then the tribunal decided it should be granted not only to employees within employment relationship, but also to others, performers of work, for remuneration, and defining or formulating this notion of employee in constitutional sense, it pointed at some criteria that need to be met by people to be part of the definition. And there were 3 criteria mentioned by the tribunal. First of all, performing work for remuneration, then remaining in a legal relationship regardless of the kind of this relationship with the entity for which work is provided, and then having professional interests connected with performing work that can be protected in a collective way. So the tribunal said that in this constitutional sense, self-employed are also included. And it is then translated clearly into legal regulations due to these considerations of the tribunal. In 2019, there was amendment of a collective labor law, and thanks to this amendment, new notions appeared in the law on trade unions. First of all, a person performing work for remuneration, which is included with a broad scope of protection in collective relationship of employment. So if it is a person performing work for remuneration, it is not only employees, but also other people who personally perform such work. Interestingly, the legislator provided for a new notion of employer, which is very much different from the employer that we know in the labor code. As understood by the collective labor law, an employer is not only an employer according to the code, but also an entity, organizational entity, even without legal personality, performing work for remuneration regardless of the legal basis for employment. And this regulation, as for collective labor law, begins to enter into force, because so far it was problematic to implement these legal regulations. And this year, October, the first trade union was registered, and it is the trade union bringing together people who are self-employed. It is called wbrew, so it means against. And I'm quite curious what will be happening there in practice, how legal regulations will function in this case in practice. So the discussion on redefinition is caused by various processes that we observe in the economy, in the labor market. There is globalization, development of new technologies, tele-IT technologies, and there is artificial intelligence in place. There are situations when via artificial intelligence people are employed. Internet platforms have been developing, and due to all these factors, we start to rethink these concepts, whether they should be maintained in their current shape or perhaps they should be modified. And here, let me move on to the second part of my presentation, in which I will try to discuss a possible necessity to redefine the concept of employee and employer. And what I can say for certain at the beginning of this part of my presentation is that the labor law will be definitely transforming and moving towards employment law. It is unavoidable, in my opinion, and unstoppable. That's the process which is taking place. So labor law will be deregulation, which will not only specifically define the status of employee and employer in the traditional sense, but it will broaden its scope and the scope of regulations to include non-employment forms of providing work. You can see it in collective labor law in Poland, because even now we can call it a collective employment law regulating the status of non-employers in the context of collective rights. But now I will try to answer this question, whether it is necessary to redefine the concepts of employee and employer. I can see two things here. The first concept, and I'm not a proponent of the first one, but it has its advocates in the science of labor law. It is the concept of modification of the definition of an employee and employer, moving towards a very broad notion. So according to this concept, let us move away from this subordinate work paradigm, and let's decide that the employee is not only a person who traditionally is defined as employee, so people employed to provide subordinated work, but to this catalog of employees, we should also add people who are employed outside of employment relationship, whether there is no subordination relation. It is also including self-employed. So people or people, yes, self-employed. Sorry, the speaker is now checking the slide because I guess it is the wrong slide. And there is a remark from the speaker that perhaps something got stuck on the screen. All right, so now let me refer to a broader concept or a broader definition of employee. Well, when I look at it, I can see some advantages and disadvantages. First of all, a question crops up. To what extent we should broaden the notion? Would we say that employees are to be people performing work for remuneration, or possibly should it also include people who perform work which is free of charge? So volunteers or traineeship, if it is part of your traineeship. So there are doubts as to the scope of this definition. Secondly, there is a risk and a significant threat to the concept, namely blurring certain lines and blurring certain traditional structures and institutions of the labor relationship and employment relationship, like moving away from the paradigm of voluntary subordinated work. Here I would like to point out, you may remember what Professor Zieliński said many years ago. He said that the labor law is connected immanently with subordination of employees, voluntary subordination. So moving away from this concept may lead to the end of the labor law, so like annihilation of this field of law. So there is this risk. There is another risk of labor law, which will be no longer separate as the field of law. And then we need like uniform employment contract, including both employees and non-employees. And there are so many differences in status of people performing work. And due to that, I guess, a uniform structure of employment contract will not be possible, because on the one hand, we have employees, like traditional sense employees, who are employed within relationship of employment, and they perform work at the risk of employer. And there is the other extreme. There are people who are self-employed. They are autonomous. There is no subordination relations there. And the risk of running their own business activity is only up to them. So a uniform definition will be very difficult here. And another option of solving this problem is as follows. And I would say I'm a proponent of this option.
dotychczasowej
It is to
definicji
maintain the
pracownika i
current
pracodawcy,
concept of employee and employer that we have had so far, so the definition which is based on the paradigm of subordinated work. I wouldn't give up on that. I believe that we should maintain this definition of employee as a physical person performing work for remuneration guided by the employer in the conditions of subordination, and this category of people has to have the broadest scope of protection in the labor law. Let me digress. There is a need to be more precise as to the criterion of subordination, because now this criterion is so blurred and so ambiguous that it raises many concerns and problems with interpretation. Apart from this notion of employee, I would think about the possibility to build additional categories of quasi employees, so people which perform work on a non-employment basis, but they need protection. When we talk about quasi-employees, it is nothing new, because as early as in the 1970s, the first categories like that were created by our legislator. Let me quote cottage work. There was regulation from 1975, and there were like employee rights to cottage workers. In the 1980s, regulations like that were introduced for members of the agricultural cooperatives, and then another categories are agents. There are some protection regulations there as well. Another category is people who are self-employed. And then another category which requires regulations in the labor law, people employed by means of internet platforms. So there are some select categories of people who need protection, but this protection should be a certain supplementation of this traditional labor or employment relationship, because I believe that the specifics of these non-employment formulas needs to be reflected in the scope of protection. This protection cannot be as broad as in the case of traditional employee who performs work which is subordinated work, and he or she is dependent on employer. The scope of protection has to be adjusted to a special situation of individual categories and specific groups of people performing work. And now I'm trying to sum up my presentation and wrap it up, and I would like to present my conclusions. So, first of all, I believe that there is a need to start a discussion on the concepts of employee and employers, and many factors point to the fact that this discussion needs to be conducted. I personally believe that we should maintain the current concepts of employee as a physical person performing work for remuneration, and it is organized by an employer, and it is subordinated work. There is a necessity to create separate categories of quasi-employees for whom we should apply some special protection regulations. It would be about complex regulations, which would take into account specifics of individual categories of people performing work, for example, the self-employed. Here, our legislator in Poland needs to do so much more, because legal regulations pertaining to the self-employed at the moment are very chaotic. Not much cohesion, there is no leading thought, no complex approach to the issues of protection, there is no order in the criteria on the basis of which protection should be granted to the self-employed. And very often the legislator takes a shortcut and says that you are referred to other regulations dedicated to traditional employees. In our law, there is no criterion of economic dependence as the criterion that should be the differentiating factor for the scope of protection for non-employment formulas. Finally, another important issue, it was mentioned by Professor Florek, there is a necessity to strengthen
w zakresie egzekwowania
efficiency
przepisów, które
in
mają przeciwdziałać
executing
stosowaniu
regulations which are to
porządnych,
prevent the apparent
stosunków niepracowniczych
non-employment
do zatrudnienia
relations
pracowniczego. To znaczy
to
w naszym prawie obecnie są odpowiednie
employment
instrumenty, które
formulas.
pozwalają
So what I mean by that, there are some
artykuł
tools in our
22
law
kodeksu pracy, który
which
wyraźnie
allow to
wskazuje
execute
na to, że,
Article 22, which
praca
says
w warunkach
specifically that work
charakterystycznych dla stosunku pracy jest
under employment relationship
zatrudnieniem pracowniczym. Niestety jednak praktyka Państwowej
is
Inspekcji Pracy i
employment
Sądów Pracy moim
formula,
zdaniem nie do końca
yet the practice at various courts is not adjusted to that. And I would say that these regulations are not fully executed. So in Poland there are plenty of pathologies like application of civil law contracts or non-employment formulas to conditions which are typical of a regular employment relation. So many people performing work in non-employment formulas actually have a status of employee, and we should simply emphasize that. That's all from me. Thank you very much for your attention. Thank you very much indeed. Thank you, Professor. It was Professor Duraj. Do we have any questions or remarks now?
Prosimy. Może ktoś poda mikrofon.
Eliza Maniewska. To jest włączone, tak? Przepraszam, a mógłby Pan włączyć? Nie, włączone chyba, tak. Eliza Maniewska, Uniwersytet Warszawski.
My name is Eliza Maniewska and I work at the University of Warsaw. So I have questions to the speakers, and I have very many questions, so I'm just wondering whether we have enough time for that. So as for the first paper by Professor Antonio Lesi, my question is whether in connection with his project, was he thinking about his potential conclusions as regards informing those who start employment about the algorithm that rules the employment, because this is the key. Because actually this is the key. It's obvious that the algorithm is created by people. Initially, these algorithms were based on very simple formulas, and nowadays this algorithm, they simply retrieve from the system all the logics, and the information about the algorithm is the key to structure concepts and actually the structure defense against potential abuses. And also, did you analyze the need, or did you research the need of educating young employees, young people, for whom the presence of algorithm is an constant and fixed feature of that concept, I would say, and I would risk the statement that most young people who start employment, they don't even wonder why such decision is generated by the algorithm, because in the algorithmic work relations, we must be aware that algorithm is not only used to manage work, but also to generate substitutes of declarations of intent when it comes to altering, modifying, changes, or terminating work relations. As for Professor Włodarczyk, I wanted to add about the social function of social guarantees of persons in employment in a broader context. Well, nowadays it is quite popular that employee rights are analyzed in the context of human rights of the second generation, and also bear in mind what the what the origin of human rights was. So that was created on the basis of the construct that comes with human rights. So that was after World War II. Well, these are social rights, economic rights, the guarantee of safety and security, the guarantee that employees will never be susceptible to criminal systems that preyed on the economic feebleness of citizens. That was a populistic policy. So it's not only about the guarantee of sustainable living, but it's about the guarantee of the future of the world. And I absolutely agree with Professor Włodarczyk. And that was seconded by Professor Duraj, that absolutely the protection of persons in employment, and I use this broad concept here, it doesn't need to be the same in all contexts, and I fully agree that it should be differentiated depending on the type of the relationship that connects employer and employees. And I was very much interested in the contribution given by Professor Wracny. And my question is about your reflection, Professor, when it comes to the principle in the context of the social teaching of ecclesiastical teaching. So would you be more inclined to understand that principle of subsidiarity from the preamble of the Constitution as a question about the scope to which the state replaces or interferes with the person's decision about the basis for employment. And I will shortly refer to what Professor Ćwiertniak said, because his presentation was very close to my understanding, the introduction of good order and structure in the notions and concepts. So I would say that Professor Ćwiertniak, he proposed the aggregate concept here, and as I understand, that boils down to the segmentation of a notion of an employee and employer because of the subcategory of elementary notions that connect these parties. And then we have the notion of a work relation, employment relation, which is approached as a complex issue. So what, as mentioned by Professor Duraj, as mentioned by Professor Włodarczyk, well, that convinces me that I'm also must take the floor, and I'm scheduled to speak tomorrow. And my paper is about emphasizing the importance of having good understanding of concepts, of notions, of definitions. And my paper is about differentiating between real and nominal definitions. So it's important that we realize that, because we have that linguistic entanglement. So I thank you very much for these presentations, these contributions, and I would like to hear your answers to my questions if possible. Thank you. Thank you. Can we have replies? Can we have answers from the speakers, perhaps in the order of your presentation? Professor Aloisi, the floor is yours.
Yes, I will be very brief. Thank you for your contribution. I'm very happy that the knowledge, the literacy in terms of understanding the logics, the parameters, and also the operation of algorithms has been mentioned by the professor who intervened before. Now, there are several examples where the litigation has been mobilized against the opacity of algorithms. And there are also examples of regulation that has been used to ensure the right to information. The Spanish example is a prominent one. Some months ago, the new rider law was approved. The law both includes a presumption of employment, but it also allows works councils and workers' representatives, broadly speaking, to be informed about the logic of those algorithms that are used to basically complete prerogatives that were traditionally attributed to employers. I don't know if this is a generational cleavage, as was mentioned by the professor. It's not a matter of young workers versus more senior workers. It's about basically understanding the impact and the effect of algorithms that somehow are taking decisions at the workplace. My idea here, as far as I understand, by looking at the literature and also by looking at the expert opinion of people working in machine learning and artificial intelligence, we don't need to become trained in the internal operation of algorithms. We must resort to traditional remedies that are available to lawyers, trade unionists, and representatives that are based on presumption, that are based on the key principle enshrined in documents and legal tools such as the General Data Protection Regulation, the principle of data minimization, of proportionality, the principle of lawfulness, and in many countries, basically the key principle when it comes to adopting technologies that are used for monitoring, assessment, and even for firing in some cases is the involvement of collective partners, of social partners, an involvement that is based on the need to ensure transparency of this tool. Now, the co-determination model, which is already in place in countries such as Spain, Italy, Germany, is a key tool that can be used basically to normalize the adoption of algorithms to avoid that these tools are considered to be falling in any legal vacuum. This is the recipe for basically addressing the challenges posed by algorithms. I'm well aware that they may be ambiguous, that in some cases they are used also in the pre-hiring phase, so workers may not even be aware of that, but I guess that we somehow could adapt the existing legal framework by keeping in mind the massive transformation that has been brought about by new technologies such as algorithms. Thank you very much for your request for clarification.
Dziękuję bardzo panu profesorowi.
Thank you very much, Professor. Then the next question applied to Professor Włodarczyk's contribution. Oh, Professor Wratna, I'm sorry.
Chodzi o zasadę pomocniczości.
Oh, so you mean the subsidiarity principle in the Constitution? Is that right? Well, I believe that in the Pope's thoughts, there are two contradictory ideas crossing. So on the one hand, subsidiarity is one of the foundations of the Catholic social science, and that is clearly visible in Sententibus Annus. So the pillars of healthy economy, which is based on moral principles, is the economic initiative of citizens and participation. Therefore, undoubtedly, the Pope was against totalitarianism and against a totalitarian state, which wanted to control all aspects of a state and of a country. So this is the concept which is rejected by the Catholic science. So he was more prone to support the more liberal viewpoint, so that the state was needed to the extent that did not interfere with economic initiatives of citizens. But then there's this observation which manifests itself in the Pope's writings, that the capitalism in the post-communist countries in particular show this ugly face. The Pope uses adjectives such as merciless or wild capitalism, and then he wrote about healthy and unhealthy capitalism, and he was also calling certain manifestations of the capitalism degenerated capitalism. In one of his encyclicals, he wrote about some aspects of employment, corporations, international corporations, who through their policy cause a great evil. Also, when it comes to the direct employment relations, these large corporations are not directly, or perhaps are not at all, responsible for all the employee-employer relations, and the role of the state is to protect its residents, its citizens from excessive interventions. So in the period of transformation in the post-communist countries, the principle of subsidiarity must come second to the principle of the state moderating economic relations to a larger extent than anywhere else.
Czyli przypisuje szczególną rolę państwu i organizacjom międzynarodowym.
So that would be the role of a state and international organizations like WHO and FAO, as the organizations that have this special responsibility to for the healthy economic growth, economic development, opposing that capitalism, unhealthy capitalism. But it's not only about the local capitalism. I think that the Pope meant that in Poland, foreign capital was Poland was entered by foreign capital, international holdings that resulted in this merciless and degenerated capitalism, although the relations between national and international capital, well, that is difficult to find the right balance between these two types of capitalisms. Well, thank you very much for this very interesting question. And about the subsidiarity principle. In labor law, we say that the subsidiarity principle requires development of autonomous forms of legislative initiatives. The Pope didn't notice that it's not in the labor law. The It's about the role of the state and the role of the citizens. We're talking here about the collective labor law.
Ale tam układy zbiorowe pracy wymienione
So
są
collective labor agreements they are mentioned in one spot in the encyclica.
jako element tego pracodawcy.
So actually they are referred to as an element of an indirect employer.
Korporacje międzynarodowe, to jakie wrażenie, żeby to, czy to jest jakaś forma może właśnie niedobrego wpływu na gospodarkę.
So perhaps these international corporations, that could be a form of a not good impact on the local economy, but I don't think that that was the concept that was presented by the Holy Father.
Ja bardzo ogólnie powiem, że
Answer will be quite general. It is unavoidable that such concepts will change. The concept of employee will change because there are new forms of employment. No one is doubting that, but we can't do it in an abstract way. It has to be connected with specific cases or formulas of employment. What do I mean by that? These need to be real manifestations of employment. Part of this discussion focuses on historical formulas. I don't know about cottage work. I'm not sure whether it appears or not. When I read about agricultural collectives or cooperatives, well, no, it is not a formula of employment. They are interested in the prices of purchase, not in employment rights or employment protection. So many years ago, I wrote an article for a German publication who was entitled to insurance in the pre-war period, and the editor told me, write about positives and negatives, advantages and disadvantages, and I met this person in German and I asked why I was supposed to write about disadvantages. All right, because, well, he had some reference point because he said, all right, everyone coming to Germany said they had been entitled to insurance beforehand. And I was curious whether it was, anyway, what I mean, we don't want just historical perspective. We want to focus on current formulas of employment. And I believe a presentation by Professor Duray was very useful because we need to think what rights which groups of employees should have. It is like in the campaign by Bill Clinton. Who will pay the bill? Bill, who will pay the bill? Play on words. Well, it would have to be connected with some burdens like premiums for this group. Or, I don't know, we will have to be quite insightful about that. So, anyway, we need to have this contemporary approach. I guess that's all from me. Anyone else who would like to comment on the first session, or perhaps you have some questions, remarks? Anyone in the room? All right, so there are no other questions. So now it's time for a brief coffee break. Because we've prolonged the first session. There were highly interesting contributions, but unfortunately we have to stick to our time limits. A short coffee break. Thank you.
Dzień dobry Państwu ponownie.
Good afternoon, ladies and gentlemen, once again. Can you hear me? Can you hear me? Please tell me whether you can hear me clearly. All right, I can see that some people are nodding. Ladies and gentlemen, let me welcome you once again as the moderator of our second thematic session. Many thanks to the organizers for giving me that role. Now we are going to talk about the concept of employer in the era of new technologies. It is highly topical, very current. Now it is being debated very hotly, and the problems which are connected with the category of employer in the light of new technologies are numerous, and there are many issues around it. There are many questions that we ask to ourselves, and all of them are debated. New questions keep on coming. As for organization of our panel, I have the following proposals. The speakers will have 15 minutes per presentation. 5 minutes before the end of your presentation, I would give a signal to you that you are about to wrap it up. As for the participants of the conference, please ask questions if you are on site. You can do it in the traditional way, but if there are online participants, you may ask questions on the chat. There is a possibility to ask a question in the chat. I will observe it. If there is a question in the chat, we'll try to answer them later on in the Q&A session towards the end of the panel. So maybe that's the good solution. All right, please stick to your time limits because our time is quite limited and we are already delayed. So many thanks. And now it's time for the first speaker. It is Professor Paweł Nowik, the John Paul II Catholic University of Lublin. The title of his presentation, Artificial Intelligence as an Employer, Reflections on the Digital Subjectivity. The floor is yours, Professor.
Dziękuję, panie profesorze.
Professor, at the beginning, many thanks for organizers. Congratulations, that's the second conference, and it is again on a very high level in terms of subject matter. It is also very well organized, so great work, thank you. A great business card showing how good the Faculty of Law in Rzeszów is. Many thanks, congratulations, thank you for inviting me. It is quite a theoretical topic, I would say, so AI as an employer. Ladies and gentlemen, at the beginning, let us think what artificial intelligence is. Because if we want to ask a question whether it can be an employer and whether it should have legal subjectivity, perhaps let's start at the beginning. So artificial intelligence as a concept. Here, as we know, it is a notion, as many issues connected with new technologies, these are issues which are difficult to describe them theoretically. So let us think about the system of notions which would describe this reality pertinently, so that we can prepare future legal regulations and their interpretations on a certain body of theories and theoretical concepts which are cohesive. And on the basis of new technologies, we can see to what extent we need to pay attention to the dogma in the law. So artificial intelligence, it is very difficult to define what it really is if we want to apply or define it in the context of a legal language. But we have the first attempt at a legal definition of artificial intelligence. It is the the draft resolution by the Parliament and the Council of the European Union, which mentions unified legal regulations of AI, and there is a definition of AI, which means software prepared using at least by at least one technologies specified by the legislator in the annex to the regulation, and which may, for certain goals specified by man, generate the results such as content, forecasts, recommendations, and decision-making, so decisions influencing the environment. And artificial intelligence is entering into interaction with the environment. So if we look at this definition, and if we try to transpose it into the concept of an employer, we can see that artificial intelligence is beginning to meet the criteria which are very close to how we see the role of an employer. Content, recommendations, forecasts, decisions, interactions with the environment, generating results. You may notice that when we talk about AI, we talk about a software. The first concepts on subjectivity of AI were more connected with autonomous robots. Here, we can see that it took a step further, and we are beginning to talk about an employer or AI from the perspective of a software. So, we have a certain draft regulation mentioning what AI is. Its expansion is connected with technologies, and it appears in the traditional labor environment and in internet platforms in a very broad scope of the definition. And internet platforms, especially the crowd working and the like, is a very interesting laboratory where we can observe how AI not only fulfills the role of an employer, but takes over all the functions of employer. So, obviously, we have the systems about monitoring software application, surveillance applications, wearable technologies, so technologies which help by people analytics, which help in this way. They simply operate on large sets of data, on methods on collecting and aggregating data in order to measure, provide forecasts, prepare reports about efficiency of employee or employees, design workplaces, manage talents of employees, and perform various options connected with the traditional notion of a work environment. The carrier of the system is algorithmic management system. It is a separate concept, highly interesting. We want to look at it from the perspective of the labor law, but algorithm management is a carrier of all these values connected with functioning of an autonomous employer, namely artificial intelligence as an employer. And there are studies, as it always happens in science, studies about evolution, the change of the role of a concept of employer, and it turns out that we have very interesting studies which show that, for example, it is by Gartner, and by 2030, AI development will replace many jobs in managerial sphere. We are observing that in various internet platforms. There are three major criteria which are decisive for that. First of all, capacity to make decisions on a huge sets of data. AI can scan large sets of data and apply prediction algorithms in order to optimize this organizational and managerial aspect. Secondly, cost effectiveness. If the technology is quite expensive, But later on, the costs are reduced. I'm talking about the costs of management. I'm not talking about costs of replacement of employees. I'm talking about personal management. And then thirdly, availability, 24/7. Human bosses, human managers. Then, when we look at these general factors, we can think about the next step. So, how it can be translated into the labor law? What are implications for the labor law? AI, defined by the European Parliament and the Council in the draft regulation, and they were discussed in a very serious way, especially at the level of the European Commission and the European Union. There are two arguments which appear there. The first arguments pertain to AI perceived as a strong AI, which means whether we should discuss digital subjectivity or not, and then weak AI. Strong AI is the technology which is very close to human intelligence. Maybe does not reach the level of human intelligence yet, but it reaches parameters which gives it a very high level of autonomy. And now several remarks about strong AI, and then there will be remarks about weak AI, and there will be some ethical concerns. I will definitely refer to personalism mentioned by Professor Wratny, because I believe these considerations are still very topical. So first of all, strong AI. Obviously, everything began with the Parliament's resolution 2017 on law on robotics, which included the postulate that creation in the longer run, a special legal status for robots should be taken into account so that the most advanced autonomous robots were equipped in legal subjectivity. And a proposal was introduced to have an electronic person. We have a legal person, physical person, and we should have an electronic person. It was actually, it caused a very lively debate among scientists. There was a powerful reaction from various scientific milieux who were against such a concept, against electronic personhood or electronic person, because treating a technology equally to a human being, because there is always a human being behind any kind of subjectivity, be it a legal person or a physical person. Well, scientists couldn't come to terms with that, because there was an argument like that. Obviously, there was a special committee, Social and Economic Committee, which expressed their negative opinion, a group of experts responsible for implementation of new technologies, and there are many arguments for that matter. Finally, the European Commission, in the draft resolution on regulation on AI, does not approve the solution about electronic personhood or electronic subjectivity, but the problem is not fully solved. If we look at the legal regulations about work environment and algorithm management, the main argument that granting legal subjectivity to AI would mean that they are treated as human beings, well, that's the argument which is like the crowning argument against subjectivity. There are also other arguments like functionality of this concept, which is not known to the practice, not known to the doctrine, several other arguments, but I don't have time to discuss them. I wrote a lot about that in a publication in the UK this summer, Computer Law and Security Review, and there is a very in-depth article about that in this publication, about various concepts of subjectivity. But what I'm interested in especially is that, well, maybe it is not the time now, but it can happen in the future, namely, in the literature, Article 54 is mentioned of the Treaty on Functioning of the European Union, because we could deduce such subjectivity from that article. We should have a separate debate about that. I'm just signaling the problem. That if you think about the legislation, this perspective, I don't think there are big obstacles there. It is quite feasible. Now, let us think about the second concept, because the first one assumes that AI is at the level of a strong AI, very autonomous, at the level of highly advanced and highly specialized robotics, and there are many arguments about subjectivity of weak AI. So the alternative interpretation means that electronic subjectivity would not express a new kind of subjectivity. It would be rather granting AI an artificial formula of legal personhood due to very pragmatic approach. Approach to what? To responsibility. If we have algorithm management and we have the technology managing the process, who is responsible for that? Who is responsible for the decisions made by the technology? Is it the person designing the technology, the person who buys the technology? In the managerial environment or algorithm-based management, there is a problem with identification of parties to the employment relationship. All right, 3 minutes to the end. Okay, so ladies and gentlemen, these proposals pertaining to electronic personhood and electronic subjectivity are based on the following approach. Let us not look at the ontology of a given device or technology or software. Let us look for legal solutions. Let us look for solutions which, just like organizations, like associations or foundations, could participate in the costs connected with responsibility and accountability of entities like that. So if there is an insurance fund, such an entity, so AI, would be also responsible for various activities. I know it is a very complex, comprehensive problem, and I can only signal certain aspects because our time limits are very limited and the subject matter is very complex. There is also an ethical issue here. So how do we understand work environment and what is the goal of work? And here thinking about AI as an employer requires a very cautious approach and careful approach to technology from ethical point of view. Let us go back to Philadelphia Declaration and think about how we understand that general declaration that work is not a kind of goods. If it is not a commodity, it means that the goal of work is a human being. So the international standards focus especially on development of a human being as a person in relation between various human beings, so interpersonal relations. So AI includes various elements on certain signs which are treated as information bits. And its understanding comes from a human being, and at the end of the day is directed and focused on a human being. So the whole way of thinking, like personalism and personalistic approach about the goal of work, becomes extremely significant here. And apart from that, the last issue actually in my presentation is to what extent development of new technologies and innovation systems which are connected with algorithm-based management will make it possible to learn about this work environments. What's the perspective, like more pragmatic perspective? And I will disagree with Professor Aloisi that it has to be reactive. No, I think that among employee rights in algorithm management is the right to have transparency of algorithms. And in this context, it is not only about reactive approach, but social partners and trade unions or other institutions in the collective labor law should have a right to co-shape the system of algorithm-based management in a given workplace. I do apologize for being so brief. These are just bullet points. But first of all, you may look at my publication, which is more detailed. Secondly, I guess there will be another publication after this particular conference, and I will be more in depth, more detailed there. But when I'm listening about the encyclical Laborem Exercens and Professor Wracny, the man versus technology, I guess these reflections are still topical. They are very current, very important, even though they were described and they were written down in a different political context. Thank you very much for your attention. Thank you, Professor. Thank you for a highly inspiring presentation. It's the first presentation in our panel, and now let me just say that there is no connection with Professor José Antonio Fernández Avíez from the University of Granada. Due to that, the next speaker will be Professor Krzysztof Stefański from the University of Łódź, the chair of the labor law, and he's going to talk about artificial intelligence as an employer. The floor is yours, Professor.
Dziękuję bardzo, panie profesorze.
Thank you so much, Professor. And I welcome you, ladies and gentlemen. I'm speaking from the city of Łódź. I wish I could be with you, but unfortunately for family reasons that was not possible. I suffer from this lack of this direct contact with you because my contribution is actually not a presentation per se. I would like to engage you into a heated debate, and I'll try to do it nevertheless. So the title of my presentation is a form of a question. Artificial intelligence as an employer? Question mark. So my question is, what is it? It decides about employing staff, it sets out tasks and responsibilities to employees, defines the mode of work control, performs surveillance over employees, has a catalog of awards and fines and penalties, and decides about redundancies. So you may have all answered that that is basically an employer. So let's leave it for a moment and let me explain why would I want to talk about AI. This technology exists, and this is not science fiction. This is not a matter of what is going to happen in thousands of years or in few years. We have our mobile phones with algorithms of artificial intelligence. If we listen to YouTube or Spotify, then we have also suggestions, personalized ads, GPS that guides us. Well, these are all results and manifestations of AI, and AI also grows very rapidly, and its progress is spectacular. Finally, this is a technology that can change our world in an unprecedented way. It is going to influence the labor market, the terms and conditions of work, and artificial intelligence is even now present at every single stage of work relation. So, upon entering into employment relation, we have tools that support or perhaps work for employer when in the recruitment process, and which are used by actually all large corporations globally, and an increasing number of smaller companies use it too. So AI analyzes forms, sets out the paths for contacting candidates, and that is a time-saving factor, and it is an excellent way for the candidate to find out whether he's employed or not. And obviously there are some doubts. I can only signal them for the lack of time, so that's the matter of access to the analysis of candidates database, discrimination, such as uncertainty of the data fed into the system, certain faults in the algorithm, as these algorithms are human-created algorithms, they carry certain biases. And then lack of transparency of the system, a lack of control of the system. Well, the systems that suffer from such deficiencies, they cannot have a transparent follow-through process. Then we have the stage of work performance, so selection of employees, preferences, recommendation of work. In courier companies, it is an app that sets out tasks and methods for task performance, the sequence, the order, definition of work standards. Recently, there was this example of Amazon together with my colleague at the Polish Parliament. We could hear trade union activists from Amazon who complain about the algorithm setting out work standards and setting and using work performance of the top employees as a reference point. And then in office work, mouse clicking, activity, etc., notifications of those who may not be diligently performing the work, then following drivers, surveillance of drivers, or the obligation to check box at every single location, and cameras which are AI related, and analyze smile. We're servicing clients. The employee who does smile is perceived as a more friendly person than the one that doesn't. And then while it all was initiated in China, it spreads across the world. And for example, one of the Polish banks, PKO, uses such technology in one of its units. And actually, the ombudsman had some objections to application of such techniques. And then there are algorithms that affect this bonus decisions for top performers. And here again, we have certain lack of transparencies. Amazon claims that algorithms and how they are built and operated, that's the trade secret. And employees, they complain about misrepresentation of their performance. Then selection of staff for group redundancies. We all know that employers may define the work redundancy criteria so that the person who are not made redundant are the best from the employer's point of view. So AI is excellent because it's an emotion-free tool to analyze all the terms and conditions. Similarly, when deciding on group redundancies in Amazon, the algorithm calculates the employee efficiency, the employee effectiveness, and such employees who are not up whose performance is not up to a standard, they receive notifications about potential redundancies. And again, we suffer from this lack of transparency when we are notified about termination of employment relation. In particular, when we are not, we do not need to be notified about the reasons for termination of the employment relation in case of short-term contracts. And with that, One may ask this core question, so whether the AI is a tool that supports the employer or whether it's a tool that replaces the employer in the decision-making process. If it is only a tool facilitating or supporting or complementing employers' work, it's okay. But if this is a man-made decision, the question is how long can we continue this way? We are labor law lawyers and experts, so we focus on humans, and I love it and I'm happy about it. But such decisions, I know, Professor, 5 minutes. So such decisions are made in the economy, and these are very serious decisions that concern employees and their collective groups. And then artificial intelligence makes far-reaching decisions about selling stock packages of $1 million of worth. So artificial intelligence sets out automatically parameters regarding buying and selling financial instruments without involvement of humans or with very limited engagement of humans. So the question is that how much longer this artificial intelligence will remain a tool and a tool only? I don't think it's going to be long. Well, obviously, we lawyers will be saying that these are employers who will be making decisions and who are responsible for discriminatory nature of such decisions. But the employer will say, why would it be me to be held responsible? I don't even know how the algorithm works. It may be the creator of the algorithm or the entity that created the algorithm. So let us go back to the key question. So as I said, the AI decides about employment of an employee, sets out tools and the mode and the standards for task performance, and holds employees accountable, decides on selecting employees for redundancies. So we said at the very beginning that we have an employer, and as we are human focused, we believe that only a human being can have this personality, can be a subject. Who is your employer? Are you employed by the state or by a university, by a company, or by an entity? So are we that far from recognizing that artificial intelligence is in fact your employer per se? Well, actually, this is not my goal to persuade you that we must recognize artificial intelligence as a potential employer. I'm all for a scientific, academic debate. I believe that we should be looking at these topics, and it's high time that we approach these topics and we look at these topics not only from the point of view of the EU but also from our point of view. But now, if you allow me, Mr. Chairman, I'll have a product placement. So it's a personalized ad, so persons interested in social issues related to AI, I strongly invite you to work with us at the Faculty of Law and Administration. We have this task force analyzing the impact of the artificial intelligence on the labor law and the social context. And so if you go to our website, well, you can find us there, and please contact us if you're interested and you want to work with us. Thank you so much, Professor.
za ciekawe wystąpienie. No tak.
Thank you very much for this highly interesting presentation. I have a reflection now that perhaps there is a lot of pessimism there in your reflections, but the last words and your encouragement for us to discuss it further perhaps provoke us to look for more positive ideas there. And now it's time for the next speaker, Professor Marco Biasi from the University of Milan, Italy. And he is going to talk about the following: beyond employment, recent trajectories in the regulation of platform work. Now the title is translated into Polish. All right. Do we have a connection with Professor Biasi? Do we have Professor Marco Biasi online? It is actually a question to our organizers.
Yes, I am. I am here. Good afternoon.
All right. If Professor is here, the floor is yours, Professor.
Thank you very much, moderator and Professor Moderator, and thanks to the organizer. My deep thanks to the organizer for inviting me. That's a huge opportunity for me to give the contribution in such an interesting event. Somehow I am sorry not to be there with you. I would love to be there with you, but also I have to confess that I have a flu now. So I've been conducting in the late years, and I've been hopefully finalizing next year as I will be visiting professor at the University of Stanford, and hopefully finalizing this project. Basically, how does my presentation complement or interact with the other presentation of my panel? Basically, it serves as a complement to the very interesting presentations that anticipated and previewed mine, insofar as my basic question is the following. Assuming that not all the platform work can be inferred or referred to the situation of full employment, so basically employment protection, which duties should we impose upon or pin upon the companies which organize and manage the work of the platforms? Assuming that they are not employers, at least not all of them are regular and genuine employers of the people working for the platform. Which rights and duties do the two parties of such a relationship have to be conferred upon? So, as we all know, I will go as quickly and sharply towards the second part of my presentation. Actually, 25 slides, it wouldn't be possible to manage in just 15 minutes. What I want to stress on is that from a comparative perspective, we might see that the courts all over the different jurisdictions or throughout the all different jurisdictions, somehow many of them classified the work performed by the platform workers in terms of employment, others in terms of self-employment, whereas where the legal system provide and have an intermediate category, I'm thinking about the British worker or limb worker, somehow the courts, at least part of them, part of judgments, tended to the classification towards this intermediate area of protection. So basically, classification was at the beginning, this is just a reference to the first very prominent and highly discussed and debatable decision by the California Court 2015. The classification still is a dilemma, but I don't want to address in my presentation the classification dilemma. I want to move forward to the second part of my presentation, focusing on the rights more than on the classification, which of course has a consequence in terms of rights. But let's just assume, for example, that at least a part of the working performance carried out in the platform economy is not a German employment relationship, and that's what my hypothesis is. Let's have a look at these two decisions, because in my point of view, these are very, very interesting and important for my argument. Australian Fair Work Commission, December 2017, and I would say similarly, Tribunal of Amsterdam, so in continental Europe, of course, just 1 year or 6 months later. Both these two judgments classified the working performances of these were riders, so on-demand driven riders, working for Deliveroo in the second case. The first one was a case involving a driver, Uber, or a platform-driven driver. So what did these two judgments have in common? These two judgments classified the working performances according to the law, the applicable law, as self-employment relationship. But I would say as a complementary, so additional argument, they somehow call upon the legislator to intervene by setting or improving the rights of the self-employed workers that could not be classified de jure conto, so according to the law, as purely employees, just classified as self-employed workers. So if the legislator, the judges say, basically, if the legislator think that there is a lack of protection, then it should be the legislator to intervene and to expand the worker rights, and not necessarily it's a duty or a part of a role of the court to somehow bypass or change the rules in matter of classification just to provide the adequate protection for those people that evidently are in need of protection. So let's just assume that this is the type of posture, legal posture that we should pursue. How to protect self-employed platform workers? Because if we have a look at a comparative perspective in the various solutions adopted and enacted in the different jurisdictions, we find several various forms of protection for self-employed workers. Once again, aside from misclassification cases. So we're talking about at least apparently germane non-employees or germane self-employed workers. We have a first technique of protection, which is the assimilation to employees. So we treat self-employed workers, or a part of them, as an employee is treated. So we confer upon them the same right of an employee. Second type of regulation, second type of protection, is the special regulation. So we, as policymakers, enact special statutes to address and to protect specifically areas, more or less broad areas, within self-employment. This is another type of protection, of course. Also, the intermediate category is a way to create a special protection for people who do not fall exactly within the category of employees, so category of employment. Third and last part, these techniques are not alternative. Of course, we can think about combination of the different techniques. The policymakers, so the statutes, promote the action of collective bargaining for self-employment or self-employed worker, and especially in matter of the fees. There's a huge debate, and I took part in this debate with a very minor contribution on the European Labour Law Journal on the potential issues or clashes between the collective bargaining for non-employees and antitrust law in the US, or competition law as we call it in Europe. But this is something off the topic of today. So let's just consider the first technique, and how the first technique is somehow questionable, somehow not so easy to implement. The technique of assimilation. So we treat somebody who is not an employee as if he or she is an employee. This is an example from a rather recent labor law reform in Italy, directing or addressing the so-called organized work. So the Italian legislator mandated that the whole protection of employment, so the whole employment status relationship, employment rights, are extended towards another area of self-employment, I would say a very close area to employment, part still of self-employment, whereby the client, which might be the platform, of course, organizes the working activity of the worker, also with regards to time and place of the activity. What does this regulation do? Which is the impact of such a technique of extension or better assimilation, because they are treated as if they were employees. According to the Italian Supreme Court interpreting this provision, this Article 2 of the law of 2015, with this Article 2, the law makes it somehow irrelevant whether the workers at stake, so workers that demand the protection, are in employment relationship or a self-employed relationship. This regulation is perfectly addressing the gray area between employment and self-employment, making it irrelevant the classification in terms of employee, insofar as the rights are extended also to the proximus area of organized self-employment. But the court also somehow says that not all the protection can be granted or extended towards the area of self-employment, because insofar as they are still not employees, some of the rights of the employees cannot be extended or exported, transplanted in the area of self-employment. And which rights are not extendable outside the area of employment? The rights which are not ontologically somehow reminding of the Greek philosopher Parmenides and Plato, ontologically not compatible with the condition of self-employment, creating somehow a huge debate in the legal scholarship and also in the future courts judgments on what is and which is a right that is absolutely ontologically incompatible with a working performance which is not a pure employment performance. So this technique somehow is a purposive approach to the notion of or to the employment protection, somehow expanding the notion or better the scope of the employment protection, but this is not a technique which is enough precise to tell us which protections are extended or not. So it creates somehow, it resolves some problems in terms of classification, but it also generates and creates problems in terms of selection of which rights to extend outside the area of employment, which is more a technique, or not better technique, a solution, which is more somehow comfortable for our labor lawyers in Italy, but say all across the jurisdiction, was the following decision by a merit court of Italy that somehow disregarded or not completely regarded, not completely followed the approach of the Italian Cassation Court and simply classified the working activity towards the, I would say, good old employment relationship. And this is a technique that this is an outcome that results in the shift of the technique from assimilation, Article 2, an attempt of the legislator to regulate the intermediate area between employment and self-employment, towards the most traditional category of employment subordination, which might be true in the single case, but does not resolve the problem of the rights outside of the full employment era. I don't have time to devote to also collective bargaining and collective negotiation for platform work in Italy. Of course, I just have a few minutes to touch upon a very different path followed in another country, which is my elected country, the US, and in particular California, how the legislators somehow and the courts had a very different interaction than the interaction the Italian legislator and the courts of Italy had insofar or relating to pertaining to the rights of platform workers. We know that in California and in the US, there was a huge attempt, a huge effort for the court just before or outside of the area of platform work to expand the notion of employee. So not expand the rights of the workers, but expand the notion of the employee through this so-called and very famous ABC test that somehow creates a presumption of employment which is hard to bypass or subvert by the platforms or by any client of organized activity. So ABC test tends towards the classification in terms of employment. What we also know is that this ABC test was highly contested and highly opposed by the platforms in California, which promoted a ballot a public ballot that whose result was to change or I say bypass, create a waiver to the ABC test, so to the employment classification for the platform work. And I would say as an exchange, we say rights in terms of classification, of legal classification, the platform undertook to provide some basic rights to the workers employed, or not employed, of course, but operating for the platforms. So this proposition, so-called Prop 22, which was approved and voted by the Blue California with a high majority, almost 60%, entailed an exchange between basic rights and the classification of in terms of employees. So it's basically an exchange between the status of an employee and the rights of basic rights in matter of labor for self-employed non-employees. The same or the same difficulty the U.S. workers faced when it comes to the collective regulation and collective protection, because we know, I call it a steep collective road in terms of the difficulty for riders and Uber drivers to reach and achieve rights through the collective traditional way. We know that the National Labor Relations Act is not applicable to non-employees. So the famous good old 1935 regulation of union law in the US is not applicable to platform work insofar as they are not employees. We also know that in the Seattle area, so in the state of Washington, the municipality of Seattle created or passed a special regulation to allow the Uber drivers and the for hail drivers to have a specific mechanism for the collective regulation of their working condition. It was contested by the Chamber of Commerce of Seattle, so somehow a public body, of course, with the I would say, support of the platform companies. And what was the outcome of these procedures that were brought according to the antitrust law? Once again, a new exchange, not between, like it happened in California with Prop 22, between employment classification and rights, this time between the renounce to the collective mechanism for the collective negotiation in exchange for basic rights for the workers, and in particular Uber drivers that operated for this Uber or platform company. So once again, exchange rights, collective rights in this case, for individual rights, basic rights like the remuneration, basic minimum remuneration for the drivers. So finally, I will come up with my final remarks. So I will leave the floor and the space for questions that hopefully I will receive, that I'm glad to receive. Which is the two paths that we analyzed very briefly. So two somehow polarized versions. So the Italian high and strong resilience of employment subordination, which was also accommodated by the most recent collective bargaining activity for the delivery companies, in particular at company level, classifying them as employees with some collective derogation in their rights. So once again, the tendency towards employment. And I call it the resistance of self-employment in the US, but a resistance which was not due to the judicial approach, which, as we said, tended towards the opening of the space for the classification through the ABC test as employees, so in classification as an employment relationship, but with a significant addition of rights for platform-specific platform workers. Are these two approaches by the Italian or in the Italian jurisdiction or in the US jurisdiction alternative, and are they fully satisfactory? I think they are not, neither of them is fully satisfactory, because also Professor Durai, that was giving a very interesting speech before me, we cannot rely just on employment subordination and on the universal application of employment subordination. We should take into consideration that today's economy, we might find also forms of germane self-employment relationship. This does not mean that those people do not need to be protected by labor law. The fact that they are not employees is not a good explanation, not a good reason to left that unprotected or disregarded by labor law, basically. And we can find significant signs of changes in the approach of labor law towards the expansion of labor law protection in a broad sense at both international level, ILO agenda on decent work, also followed by the United Nations agenda on decent work as well, at the international level. Plus, we might also have a look at the European Pillar of Social Rights, 2017, a clear approach by the European institution moving towards or beyond employment, mirroring once again the title of my presentation. And I would say that the same is in many jurisdictions. In Italy, not only Professor Durai spoke about the constitutional provisions in other constitutions. We should rethink labor law, but rethinking labor law does not mean that we should rethink just employment subordination. Employment subordination and its bulk of rights should resist, should stay where it is, but at the same time, we should broaden our eyes, our horizon, towards the protection of the person who works, which is the extreme ultimate value of labor and the interaction with the person that works. This is the new challenge that we are all facing. Of course, I do not have time to pinpoint the rights that this person that works should be granted, at which level. There's a lot of discussion to make, but we should take a axiological position, axiological posture towards the expansion of worker rights beyond employment, which is still our cornerstone as labor lawyers. I thank you very much, and I don't want to abuse of our time.
Thank you very much indeed, Professor. You've exceeded your time just by a very small fraction, so you were very disciplined. Thank you very much for that. Other speakers were also very disciplined. Many thanks. I know that this topic is very complex, so we would need so much more time to debate that. I hope organizers will allow us to have some remarks or perhaps questions. On the chat, in the Polish part, there are no questions because I'm observing the chat all the time. Because there might be questions from our online participants. All right. Józef Niemiec has a question to Professor Biasi. I assume that from the chat. Professor Biasi, do you see the question? If you see the question in the chat, could you please answer that? Professor Biasi, can you see the question in the chat? Because I guess the question is addressed to you, Professor Biasi. All right.
I beg your pardon, but I don't see the question on...
Ja je odczytam.
Right, perhaps I will read it out.
The Union Confederation asked the EU to regulate platforms as they are multinationals and operate all member states in order to protect their workers. Would you support this view? Tutaj trzeba przesłać to pytanie ewentualnie na...
Or perhaps this question could be forwarded to the English language part of the of the platform.
Inni uczestnicy
Perhaps that can be done, but perhaps there are some questions or comments from the floor.
I beg your pardon, now I see the question, right, for me. So, should I support or not the view of European Trade Union Confederation claiming for a EU intervention in matter of platform work? Is this the question? I would be able to answer, but tell me please that this is the question and it is for me. Otherwise, I'm just interrupting the discussion, so sorry. Do you, Professor Moderator, agree that it is on me?
Yes, this is your question. Yes, this is the question to you, sir.
Okay, thank you very much, Professor. So I am in favor of such a type of intervention, but we all know that EU has a limited scope of competencies. We all know, and we are all studying now in this lately, the issue of the EU directive in matter of minimum wages. Does the EU have the competence or not in matter of wages? And there are various other aspects which might potentially not fall within the area of competence of EU. So I am definitely in favor of a EU initiative, but insofar as it somehow purports to set a minimum standard, so a floor of right in the areas of EU competencies, maybe pushing and lobbying and encouraging member states to intervene more specifically in other areas of interest and other areas of primary importance for rights at the national level. I definitely agree with you, with the observer, and I thank the observer for this very interesting question, very intriguing question, that they are multinational. So we have a transnational issue regarding platform work, but if we want to focus on the policy dimension, we should be able to combine the EU effort and considering the EU competencies with the national effort that should, in my opinion, improve or better and complement the EU intervention in the areas whereby the Union does not have a full competence, or whereby simply the member state can provide better conditions than those that are the floor established at the European level. This is my point of view. So definitely I'm down for the ETUC approach, ETUC initiative, definitely favoring it, but still we all need somehow to work together in also different fields, in different areas and different levels. Thank you very much.
Dziękuję bardzo. Thank you very much.
Are there any other questions or interventions, ladies and gentlemen, from the floor? So perhaps...
Ja jeszcze, przepraszam, zgłaszałam się.
Excuse me,
tutaj dominuje.
I apologize for being overbearing in the Q&A part, but for me, such conference is a great opportunity for exchange of opinions, and that is rendered difficult when some of you are not here with us in person. I wanted to refer to these very interesting papers referring to the artificial intelligence, and I must say that the perspective of Professor Novik is very near to my heart, and I can see this incredible danger that comes with that. So my question is about the question or the reflection on artificial intelligence becoming a person or an entity, and in this case I want to refer to court litigations and evidence-based court trials. So if we have artificial intelligence as an entity, as a subject, as a person, I do not I foresee or I believe that such a AI should be a party to a court trial, and I don't see a way of engaging into a litigation if we do not have an access to the information on how the algorithm is created. And then I have this reflection in 2017 when we were at this international conference in Prague, and it was when one of the professors said that, ladies and gentlemen, in 2-3 years' time, we'll be talking about artificial intelligence as an employer. We actually didn't care that much at that point. As you can see, this issue has grown in importance, and it consumes a major portion of our deliberations. And in a moment, in no time at all, it will see that if we have artificial intelligence as algorithm as employers, we may equally see on the employee side algorithms defending employees, in the sense that perhaps trade unions might will be governed by the chosen ones. I'm not going to say that will be ruled by gods, because my gods are different, but actually I believe that we're heading for disaster, and I believe that we should oppose to that, and the opposition should be strong. And I would like to ask Professor Nowik and Stefański to refer to that if possible at all. Professor Nowik, therefore.
Uwagę w tej kwestii.
Dziękuję bardzo za pytanie. Osoby elektroniczne mogłyby być postrzegane jako takie alternatywne.
Persons could be perceived as alternative legal persons with all consequences of that. When it comes to the concept of weak intelligence, I think two concepts can be found in literature. So the first one is expanding the concept of legal personality onto machines, according to the definition in corporate law, or by creating a new concept of legal personality. And in every single case, such entities also involved in court litigation. And then in the literature, we lack in-depth analysis of these points. I think it's more about legal argumentation, it's about legal considerations, but I haven't come across a proposal how to incorporate it into the legal system. Those who present such arguments, they believe
jakby to powiedzieć na polski tłumacząc, to jest taki determinizm z tego wynikający jest tak oczywisty,
that determinism that comes with that it is actually a crime not to consider these aspects, and in my opinion it's worthwhile to look at the whole theory of labor law at different institutions which are related to the labor code, and we should be looking at it from the technological point of view. How up to date are they? Considering their knowledge of level and preparation, it is my subjective opinion, but I can see it also in the literature, that there are so many labor law entities who operate quite well in this new reality. Against perceiving this relationship of being employed through a platform as a relationship which is not a work relationship.
być najbardziej przejrzystym obrazem funkcji.
Well, I think this is the most transparent image of a function of a subordination of employee.
Formuła zarządzania algorytmicznego to jest
And
jakaś
every
postać,
type of algorithmic management is a manner of it's a manifestation of a subordination. So I'm not convinced by the argument that in the contemporary world there are different cases, different types of subordination. In my opinion, this is a form of a parameter-based employee subordination. And here the concepts which are used in labor law apply. So for example, please name just one notion, one concept that does not apply, which does not fit to this new paradigm. So employment relation, trade union, so which of these concepts does not fit into the whole system? They should be reinterpreted, they should be reinvented. We have this evolution of the subordination concept. We had that autonomous subordination. We have subordination forms which are connected to the algorithmic management. So they all fit into the entire body of works of the labor law. So I would be all for it. Thank you, Professor Stefański. Thank you. Just very briefly, speaking about the artificial intelligence as an employee. So we see that as tools, but when we think about the future, as we heard, that is more a domain of not entirely doctrinal approach. For the time being, this is just a what if concept, and I think we'll be all going in that direction. And I believe that the artificial intelligence will have certain employee rights with time, but as for the black scenario, such black scenarios are now being created and developed, and this is an element of a bigger picture. But then we can see the impact of the artificial intelligence on the labor market. And then we can see very serious limitations of access to employment. And the artificial intelligence will actually take over very many professions. And the initial research, which was extremely pessimistic, they now show a slightly different picture. And then answering to that question about judges, I must say that it is happening right now. There are courts in Estonia which in first instance they have artificial intelligence issuing judgments or decisions when it comes to, for example, disputes for payment. And then the artificial intelligence is also used when analyzing preparation for a trial, at the stage of analyzing and preparing for trial. So the AI is already being used, and we may be predicting that the algorithms may be issuing judicial decisions in simple cases, and a similar approach will be used in the public administration. There are now certain tests being performed also in Poland to engage the AI in the public administration in the decision-making process. So the problem is already here. Now the question is about the scenario which we're sketching. Is the outlook so bleak? I think that we should monitor it, but I would disagree that we should oppose to it. I don't think it's possible to oppose such trends. I don't think that we can oppose development of technologies and ideas, and obviously we may try and make some effort to slow down or oppose certain elements like discrimination or excessive interference with or into personal data. So these are aspects that should be should be opposed, but I don't think it makes sense to say that the artificial intelligence is evil and we should oppose it wholeheartedly. Thank you. Thank you, Professor. I think that we're under time pressure. I think we should close this panel right now. I don't think we have the time to wait for more questions, but there will be more opportunities to ask more questions. And then we have yet another session with similar topics. So let me just make one comment as a moderator. My comment is as follows. I think that sometimes we are quite fascinated with the development of technological tools. And sometimes, perhaps because of that fascination, we are prone to award them autonomy and to consider them independent and autonomous entities within the confines of the existing legislation. But in my opinion, the tools, the machinery, the AI, these are only tools. There are people programmed and people controlled tools, and human beings are responsible for what is being fed in and out of the system. And then if corporations and the platforms, platform administrators, if they claim that they do not control the algorithm, this is just an attempt to evade or avoid responsibility. So after negotiations in the US on the terms and conditions of employing personnel in such circumstances, in particular when such employees are employed by platforms, well, in such cases, we're moving on to another level of discussion. So these are tools which are limited, who have their limitations, who have their constraints, which can be controlled. And this topic and this area is the area that remains open for intervention. So in the past, with conveyor belts in factories, these conveyor belts could be stopped or delayed or slowed down, etc. And I believe the same approach should be used for the artificial intelligence at this stage of technical development, and hopefully in the future a human being as a living creature is different from mechanical tools, and I think we should consider that in our debate. Because of lack of time, ladies and gentlemen, we thank you very much for your contributions, for your participation. These are very important and interesting topics and issues. Thank you very much for the questions and for your comments. And would like to give the floor back to the organizers of this conference. Thank you so much. Well, enjoy your lunch break.
Dziękuję bardzo. Nie mówię do widzenia, bo będziemy się jeszcze widzieć.
Państwa wszystkich zapraszam na obiad.
3. Raz, dwa, 3. Tu, raz, dwa, 3. Tu. 3. Raz, raz.
Dzień dobry, witam serdecznie w drugiej części naszej konferencji.
Welcome after the break.
Sesji poobiedniej.
So let us begin our next session. First of all, I would like to welcome our special guests and our on-site participants as well as online participants. And in this part of the panel, we are going to talk about the concept of employee in the context of development of new technologies. Before the lunch break, we were talking about employer mostly. As it turns out, the fruits and results of these reflections are very inspiring. The notion of an employee, well, it is a very important question. To what extent, in the light of AI, algorithmic management, new work environment, to what extent our traditional understanding of employee is still valid? And to what extent we need to come up with new concepts, or new theoretical concepts perhaps, or more pragmatic concepts based on a real work environment, where employees in a very broad sense of the word perform their work. So, among our speakers in this session, we have 4 experts, and the first person, actually it will be a duo. There will be 2 speakers, Professor Beryl de Haar and Dr. Marta Otto. And I suggest that every speaker has 15 minutes. And after each presentation of 15 minutes, we'll have a Q&A session. So I don't know who is going to go first, whether it is Professor Beryl ter Haar or Dr. Otto. I guess it is Professor ter Haar. The floor is yours. Are you the first speaker, Professor ter Haar?
In fact, Professor Novik, I will take the privilege and start our presentation. This is Marta Otto from the University of Łódź. In fact, speaking from the University of Warsaw, from the sites of the newly established Center for International and European Labor Law Studies, where I'm now with Professor Beryl ter Haar. We would like to kindly thank you for your invitation to contribute to such a topical conference, given all the developments that are taking place nowadays in the world of work. We would like to share with you today few reflections on the idea of reimagining the concept of employee at the age of AI, digital hybrid workforce. So the presentation as such will be focused around 4 points. I think we have some, okay, around 4 points, and we will be focused on general basis. It will be focused on providing tentative answers to central questions from the perspective of the relevant remodeling of the broadly understood world of work. So how will the world of work differ from the one we know? How will the relationship between the workforce employment models and work environment evolve? How can we take the advantage of such a situation in which AI masters certain skills faster and better than humans, making us change our work patterns, that is, work less and enjoy life more? And finally, what are the regulatory implications, or more specifically challenges, that we need to address in order to foster labor laws resilience in the emerging context? So the presentation, as you can see, is built upon 4 kind of complementary sub-narratives that are centered around 4 key words, namely reimagining, rethinking, reshaping, and re-regulating, all of which, in our opinion, are indispensable indeed for building solid fundaments of a new human-centric, AI-powered workplace model. So our starting point is a shared idea that, in fact, in order to shape the future, we must first imagine it. And when it comes to visualizing AI-powered world of work, as we could already hear today, we do not have to stretch our imagination too much, as already in many firms, the symptoms of such a systematic change are visible. Let me introduce you Amelia. Amelia has many skills and uses them all at work. She can deploy newly hired employees. She can help manage Amazon Web Services, and later still check that one of her employees has completed their tasks on time. However, this is not like an avatar of a really busy manager. Quite the opposite. Amelia is called the most human AI for the enterprises that was created in 2019 by Ipsoft. And in that year, Ipsoft, an international company, launched a marketplace type platform at Digital Workforce AI, within which works by, in great oversimplification, by managing to browse available employees, to interview them, and then hire them in their own company. The platform is gradually expanding specializations, but however, it is already possible to hire an engineer that in the IT department, or coordinator in the HR department. Recently, the platform has also offered Amelia for customer services, banking, insurance, and healthcare. If we look at the internationally available data, what is interesting is that many studies demonstrate that the share of digital workers in the global workforce will increase by more than 50% over the next years. The study most of the studies were conducted on a sample of top managers, top executives from firms all around the world. And yet, despite dire predictions and quite dystopic predictions about workers being replaced by intelligent machines, leading organizations worldwide are taking a new path. Namely, if you look at the data, only 12% of those surveyed indicate that they intend to replace employees with AI, while 60% put AI as a kind of additional capability enhancement. And the teams that consist of humans and AI are often referred to super teams. And this notion is very symptomatic, as in fact, the super teams, they hold the promise of allowing organizations to reinvent themselves, to create new value and meaning. But at the same time, they are giving the workers the potential to reshape their career in a way that increases their value to the organization in the broadly understood talent market. So one of the key questions that we have to ask ourselves nowadays is, to what extent are we on the brink of some kind of watershed moments in the evolving relationship between people and technology in the workplace that will soon leave their mark on the prevailing employment paradigm, including the concept of employee. And if we look at the literature that is indeed proliferating recently, the answer would be both positive, but at the same time negative, as this literature that honestly I also contributed to is very much centered upon or built upon a kind of negative risk-based narrative. So what we think with Professor Beryl Terhar is that it's really high time that we changed a bit the optics, and we think of the advent of the digital worker as a kind of historic opportunity to rehumanize the concept of employee, but also the concept of work as such. And by this rehumanization, we mean restoring a proper understanding of the role of the work, of the man in the process of the work, which above all is to serve in the end his development and his fulfillment and the realization of his humanity. What is rather self-evident already at this stage is that digital worker have the capability of replacing humans in performing routine, high volume and repetitive tasks, and therefore it may allow employees to focus on a higher value, more complex, and therefore fulfilling assignments. Of course, it is part of every kind of revolution, then some traditional jobs will disappear. Yet, as you know from the history, some will evolve. At the same time, in the world that is emerging, careers, money, and prestige are likely to be dethroned by the self-development broadly understood, also accompanied by the skills and experiences of enrichment as the main drivers for the new generation of workers. And interestingly enough, this is not like our hypothetical wishful thinking, but this kind of process seems to be already fed by the emerging socio-economic theories. And I will pass the screen, or the floor, in fact, now to Professor Beryl Terhar, who will share with you the rethinking sub-narrative, the building blocks of the rethinking narrative. Beryl, the floor is yours.
Thank you, Marta. So, a bit of an echo. Yeah, so. One second. Thanks. So for the rethinking and taking a bit of a broader perspective, one of the things that we started to look at is how are we looking at jobs and how are we valuing jobs? And also with this idea of sustainability that we're talking about more and more from an ecological point of view, we also need to do it more and more from a social point of view. So one of the people that is doing this is David Graeber, who wrote a book on bullshit jobs. And one of the interesting things that he's doing in his book, and this figure comes from it, is building on research that exists that thinks about work from not economic value, but what it actually brings us as society. Because if we're going to change the kind of world of work that we are in, because we're going to use AI and developments in AI to the positive strengths in supporting us human beings and helping us to get into a better world, then we also need to think about what are the kind of jobs that we really want to keep, how do we want to change it, what is really going to contribute to the world to make it a better place, to give added social values. And one of the things that came out of, or the researches that he builds on, is looking at the type of jobs that we have and what it is generating in, let's say, economic value in terms of social benefits, what it gives us in society. And interestingly, from two different types of researchers, and I've shown here data from one of them that has been conducted in the US. We also have one from the UK. They're quite similar. So people that are being paid a lot of money that we find in the financial sector, with managers, in advertisement, lawyers, consultants, they actually cost us as society a lot of money. In this figure, how it is expressed, so for every dollar that they are being paid, they actually distract, for example, in the financial sector, $1.50. The research that has been done in the UK gives even more shocking results. For example, a city banker with a yearly salary of £5 million earning £5 million, an estimated £7 of social value is destroyed for every pound earned. So that means that one city banker actually destroys £35 million on social value, to give an idea. So thinking from here, we took a next step about like really rethinking, if we're going more in the future, what are the things that are important? And one of the things that springs out is the ecology, the environment, the fact that we are already running into limited resources. Here and there, you'll hear that, for example, building houses is becoming more difficult because there's a shortage of wood and etc. Another thing is that we need to like reuse products more and more. So from an ecological point of view, we're going to have to rethink how we build things, how we produce things, etc. So here you also see slowly more an approach of human well-being, that what do we really need, what do we have to create for ourselves, rather than welfare, where we just take as much as we can from a more materialistic point of view. If you take together the development in artificial intelligence, what Marta also elaborated on, and we heard in previous, especially in the previous session, we will see that a lot of not necessarily jobs, but a lot of our tasks in our jobs are going to be taken over by AI, algorithms, robots, etc. At the same time, we will also see that from a sustainability point of view, from an ecological point of view, we're going to have to produce less. So if we take the two together, and we are on a path that is actually going to a lot less amount of work to say. Still, there will be jobs, probably the jobs that add value to our society, because that will come to our benefit, but it will be significantly less. That means we also need to rethink what kind of economy can we function in. And here I will, so if we look at economic thoughts that take a forward look and embrace this idea of the ecology and bringing a new balance between the 3 Ps, profit, planet, and people, you see clearly a shift moving away from profit being the first that people and planet are being subordinated to people and planet first and then profit. And one of those theories that pictures this very clearly, because the author thinks about it, is called the donut economics. And it's called donut economics because he presents it as a donut. The green circle is the donut, and the pinkish around it and on the inside, that indicates where we are kind of overusing or falling short. So overusing is everything ecological, where we are using actually more than what we can find in our donut, in our ecological system. And everything that is in the whole of the donut, that means actually that people are falling short, that you fall beneath our social foundation. And what is interesting here, what you can see, we have an economic model. And in this economic model, we find gender equality, social equity, peace and justice, income and work, education, health. These are all elements that now are outside the economy. And not part of the economic system, and for as far as they are part of the economic system, somehow are in conflict with the economic model that we are in now, capitalism, neoliberalism, based on constant growth. And one of the tasks of labor law is to balance this with these economic dynamics. If this now becomes part of the economic system, then we think we are not only reshaping the world, after having rethought our work and reimagined how work and the world of work can look like. But we're taking it a huge leap further. And with reshaping, we also need to rethink again, going back like, but then what is left? Then what do we need to do? So we have limited amount of work, limited sorts of work, probably more work of social value, because that creates well-being rather than only welfare. And it's not about the economic value, but it's more about people, planet, and then profit. More intensified work also, because what we see, what has been taken over by AI, algorithms, robotization, is those tasks in our work that can be that are repetitive, routine, can be well described, the more easy things. We might wonder, does that also lead to better quality of work? Does it necessarily have to go hand in hand? But intuitively, we might think it does. And then also, more importantly, probably, if we have a reduced number of hours, then we have also for work, we have more hours of free time. So we need to rethink also, what are we going to do with our free time? It might be that some things that have now economic value are difficult to give economic value, but have strong social value, become that what becomes important in our free time. And then we can think about sports, about music, other art activities, but also all kinds of activities that develop yourself, our capabilities development. So there will be different aspects that determine what is going to be important in our lives. So not the status in work, in our career, or how much you can buy, but your status in life. How well are you feeling? What personality do you have? What do you contribute to society in social, not economic terms, etc. So going for well-being. And with that, we also need to do some regulating. And there I give the floor back to you, Marta.
So just to restate again our main argument, we believe that the future of work is indeed both human-centric and AI-powered. In other words, in our opinion, the AI has a great potential, apart from all the risks that are already delineated there by the literature. AI indeed has the potential to drive humanity towards a better future for all, broadly understood. At the same time, in our opinion, it is pretty self-evident that harnessing the potential value while mitigating the negative requires, we call it a purposeful, human-centered, regulatory and institutional design. If we look at what we have now, namely to large extent, risk-based regulation and all the cases that were brought both before the courts or just surfaced in the public debate, it is pretty clear that the risk-based regulation is not enough. Why? Because as Professor Baratel-Haar just stated, this is mainly so because this legal architecture is very much embedded based on economic system that we are currently in, and does not and not that one that shifts the balance from people and planet being subservient to profits to one in which profits are subservient to the limits of the planet and the needs of the people. And to go there, we need full re-regulation, which in our opinion should encompass the not only the fundamental principles and rights, but also the search for the new balances between the ecological and economic rationale. And last but not least, a new labor code or codes that would encompass such a rejuvenated rationale. So thank you once again for having the opportunity to share with you today these few reflections on the future of work. And we are looking forward to all the questions that we do hope that this presentation raised in your heads. Thank you very much.
Bardzo dziękuję za tą prezentację. Dziękuję pani profesor Beryl Der-Haar i dr
Thanks for this presentation. Thank you, Professor Beryl Der-Haar and Professor Dr. Marta Otto. Actually, you've presented quite an optimistic vision of the labor market, of the world of labor. Always, if we don't know something, if we don't know the future, we are concerned, we are anxious, and you see an opportunity for a new social order there. By a redefinition of employment relationships, it will be shaped in a new way. So thank you very much for this inspiring presentation, inspiring results of your own scientific work. Thank you so much. Now let us move on to the second speaker, and it will be Dr. Kamila Naumowicz. She will talk about the legal status of persons performing work via online platforms, a comparative analysis.
Pani doktor, proszę bardzo.
Dr. Naumowicz, the floor is yours.
Dzień dobry Państwu. Thank you very much. My presentation will be in English as we have, first of all, this is an international conference and I am very pleased to take part of it. And secondly, my research is comparative, so I will be addressing some questions from other countries. That's why I wanted to present in English, and I wanted, of course, to thank very much to the organizers for organizing already the second part of this amazing event, and I am really pleased that I can be part of it. I am listening to all the panels from the morning, and I will also try in my presentation shortly to refer to the previous panels and previous excellent speakers that has addressed some questions regarding also the legal status. I will try to share my presentation now and will just kindly ask to confirm if it's working as usual. I hope it does. I just will start the slideshow. Thank you very much, Professor. Okay. My topic is the legal status of persons performing work via online platforms from a comparative perspective. I am currently in Valencia finishing my research project on the legal status of platform workers in Spain. So I will also try to put some of the concluding remarks in my short presentation. But just some introduction to the general problematic of platforms. First thing that we always have to bear in mind while talking about platforms is that there is not one type of online platform. It is very different typology of different business models that try to be seen as mediating services between clients and customers, and there are also different types of platforms regarding the tasks that are performed either online or on location. We usually think about platform work regarding the drivers or riders that perform the task on location, and that has become famous also because of the fact that many international courts has addressed the question of their legal status recently in the recent years. The second question that is important to take into consideration when we're talking about platform work is the fact that the traditional employee-employer relationship here is substituted by the seller-customer or user-user relationship, and that it has been proven in many court rulings already. It can be seen as either precariousness or even the term, which is very hard to address this question. But there are some references in literature that called platform work modern slavery, and there have been, of course, recognized some elements of traditional employment relationship also in this this type of working performance that is through platform. So many previous speakers already addressed the question of algorithmic control, digital reputation, or general the new ways empowered by technology that serve the platform to exercise the control powers over the platform workers. And there have been some actions already taken to guarantee the decent digital work. This is also the term that has been used in the discourse about platform work. So the question of legal status of platform workers is also not a new question, because it has been addressed by International Labour Organization already a couple of years ago. And ILO, in one of its reports, stated that this new form of work, that is platform work, has disrupted the existing business models, because we also have to take into consideration that it is also a different type of business model, a business activity based on the use of algorithms. But it has also disrupted the existing employment models. And this is leading us to questions regarding the legal status of persons involved in this kind of working performance, whether they are self-employed or should they be recognized as employees. The questions about looking for some elements of subordination and control in this algorithmic managerial powers of the platform, and trying to define in a new way the existing terms that we are discussing today, like employer and employee, regarding the platform work. And these questions arise also because platforms itself usually define the workers as self-employed, usually in the regulations or in the contracts with the workers, use the terms that should suggest that it is not employment relationship, that the work is not controlled by the platform. But as many court rulings stated, there are some elements that can prove that there is the bond of the employment relationship in this type of model. So in search of a recognition, this is just a slide to sum up the basic questions that occur while we are analyzing the platform work, is either we have non-standard forms of work or standard forms of work, so the traditional dichotomy between subordination and autonomy, whether we can describe platform workers are independent contractors or freelancers, are there partners, are there really user-user or user-client relationships, are there just providers or taskers. This is a category that refers to the idea of gig economy, in which the work is divided in tasks. So sometimes they are also referred to as taskers. If we think about the one particular type of platform work that is on location work, we usually refer to those workers as couriers, drivers, riders. In some states, also already in legal regulations, we have the reference to an economically, the category of economically dependent, self-employed, and in court rulings we often have the reference to employment relationships, so they are being referred or qualified as employees. And the phenomenon of platform work is important to be analyzed and discussed because in many cases, it has been already proven by labor inspections or courts, the model that platforms use is due to hide the legal qualification of the status of the workers behind this atypical model of work that is becoming more and more popular. And one thing that has been addressed in the previous panel is the fact that if we are talking about the legal status of workers, of course, we have to take into consideration, so what or who is the platform? And I won't get into details because of limited time, but we may see analyzing the jurisprudence that platform itself usually defines itself as a mere mediator between the worker, the platform worker, and the client, the user of the service. But in fact, the International Labour Organization and the courts many times declared that it cannot be seen only as mediator. It has to be analyzed in details, because in many cases the work that the platform was using and the form in which the enterprise was organized served to disguise the true employment relationship, and in fact contributing in that way to the precariousness of this type of work. These are just few examples of international jurisprudence from the last years that has been dedicated to the term of legal status of platform workers. Unfortunately, I have not enough time to analyze in details all of them. But what is important is that we have some rulings already also on the European level, but also in several countries in which the usually riders, because usually these were the types of platform workers that filed the claims among the national tribunals in countries like UK, Italy, and Spain, in order to be their legal status, in order to be recognized as employees. What is important while discussing the legal status of a platform worker is the fact that, of course, there are criteria established by the European Court of Justice, and what is important is the fact that in any case the case that has to be examined and the result of this examination cannot be merely notional. So the fact that platforms define their workers as independent contractors is not enough to prove that, in fact, they had the amount of autonomy that is needed for the workers to be truly independent. So this examination of actual realities of the work performed by the platform workers cannot be notional, and it cannot be used to disguise employment relationship. And the questions that occur while discussing the legal status were the questions addressed in the first panel, because in fact, when we are talking about the parties of employment relationship, is like my excellent professors in the first panel explain in details. It is what we intend by the employment relationship, and what is the goal, the focus, the quality of employment relationship, and the rights and obligations of the parties related to the employment relationship. So what the European Court of Justice is also asking while analyzing the working performance of platform work, what exactly is the working time? And can we consider, like in this picture, for example, the time dedicated to check if the task has been assigned by the platform? Is it a working time? What and where is the place of work? So is the time spent by the driver or rider waiting, but also going to pick up the food, for example? Is it also his place of work, or what is the place of work? Is it the territory? And if we think about not on location but online platform work, then the question of working time and working place becomes even more and more difficult. And furthermore, the question of control, because we, while recognizing the employment status, we talk a lot about the controlling power and the algorithmic control. So there are also the question if the managerial and control powers can be exercised through the online platforms, through algorithms, through not direct form of this control. And in fact, they can, because there are so many examples of the regulations and of the realities in which platform workers perform their work that led courts to decide that in fact the control power can be exercised also through the algorithmic system that decides upon the working time, about the working place, about the scoring system, so the digital reputation, and even the closure of the working relationship between the platform and the workers. And there are many cases. Unfortunately, I have limited time to explain all of them, so maybe I will just skip some slides, and I'm sorry for that. But I hope that we will have the occasion to discuss, or I can give more details in the written form. That there were some cases in which Uber or Glovo or Uber Taxi also has been put into this examination by court, and in fact the courts usually arrive to the conclusion that have been the degree of control and the level of control and the tools, the digital tools used to control, to monitor, to score, to organize the work of platform workers led to the conclusion that in fact we have some remarks of the employment relationship. And of course, the question that has been addressed also in the keynote speech today, that we also have to take into consideration. So whether the boss, so the employer, is becoming an algorithm, or is there always the human approach to this algorithmic power of control? But I won't go into details with that. So the future, and I see, Professor, that I have limited time, so I will try to just go to the most important details. The future of labor law on the Spanish legal response, like just an example of what happened and what is happening. The Spanish Supreme Court last year declared that platform riders, so the platform workers that work in the delivery services, have been declared as false autonomous. And since that, in the last 2 years, the Labor and Social Security Inspection in Spain considered that, as you can see, really high numbers, because 18,000 of those riders affiliated to digital platforms have been declared false, self-employed. And this year, Spain approved the so-called lay rider, so law that regards only riders that it's not very long. It has only 2 articles that bring some amendments to already existing regulations in labor law, but they have introduced two important changes. First is the presumption of employment status, but only for delivery riders. And second, which is very important for those of our colleagues that study the algorithmic control, is the right to information on the algorithm used by the platform. In every case when the algorithm regards the parameters, rules, on instructions that consider the working performance, so that affect the conditions of work, the access to work, the maintenance of the employment, the conditions of this employment, or the termination of employment. And what is important is that what were the reactions of the delivery platforms operating in Spain? And in fact, this is something that needs to be addressed in the future, because Deliveroo already declared that it will close its activity in Spain. Glovo instead, which is also a very big platform operating in delivery service in Spain, declares that it will adjust the model in which the riders are operating to make the autonomy and the flexibility of this relationship more according to the court rules, but without changing the legal status for most of the riders. So they will remain self-employed. In some cases, we are still waiting for the response from other platforms, but there were suggestions that they will probably use the form of subcontracting instead of recognizing the legal status. And the conclusion, so this is the last slide. The conclusion, there is a need to regulate platform work, but this is an international discussion in what way this regulation should be examined and should be applied to the platform workers in order to protect them from the main risks. And some of the proposals have been already mentioned. There is the proposal to broaden the definitions that we already know, or go beyond the employment relationship, or create third categories. There is the European proposal on the regulation for platform work that is already discussed. And of course, another proposal is just the application of the international labor standards to protect any form of work instead of the legal status. And thank you very much for your attention, and thank you very much, Professor, for the patience and letting me finish my presentation.
Bardzo dziękuję pani doktor za
Thank you very much indeed for your presentation. It was highly interesting. Now, there are many questions arising when I'm listening to your presentation, especially the view that you've expressed on assessment of features or characteristics or principles governing work via platforms, but perhaps it will be left for Q&A session. Perhaps there will be some questions or comments, and now let us move on to the next presentation. So it will be Dr. Christina Hissel from Goethe University, Frankfurt, Germany, and there will be another interesting paper. So, Professor Hissel, 15 minutes to you, if possible. Thank you.
Yes, thank you very much. Can you hear me all right? I hope so. I will try the screen share. If anything, oh, great, I have that up. If anything does not work, please inform me. Yeah? Seems to work. Okay, great. So, yes, first of all, thanks a lot again to the organizers. It is lovely to be a part of this panel. Many intriguing discussions that we have already heard. And I think my presentation is going to fit in relatively neatly, especially with the last one by Camilla. So thanks a lot for that. Yes, so what I have been dealing with for quite some time right now is the classification of platform workers in case law. And in legal studies, we usually don't do quantitative analysis so much. So what I'm doing here is going a bit into that direction. It's a work that was commissioned by the European Commission, because as we have already heard today, several times perhaps, the European Commission is currently trying, or at least planning, to regulate platform work, and is very interested in what is already there on country level. Yes, so what I've found up until now in cross-European case law, it's a work in progress. So yes, I've seen before he's here today, just yesterday midnight, I actually got a very, very valuable hint from an Austrian judge on actually 4 judgments, administrative one as well as first instance ones, that will obviously very much influence also the outcomes of this study. Because they are in a relatively rare type of platform in the case law so far. So you can just see this kind of an overview of which countries, according to my knowledge, have had decisions on platform workers so far. So it's actually more than most people would think, because in the international literature, usually it's always the same few that are really referred to. I think we have already heard about several of them. We have heard about the Italian and the Spanish and partly the UK decisions already. Yes, so I'm trying to be comprehensive in order to also reflect the enormous diversity that we have actually when it comes to platform, the enormous diversity when it comes to the specific conditions of working for them. Because as we have, I think, also seen in the previous presentations very often, there is no one-size-fits-all solution to platform work. And yes, we have already also seen that very much in national categorizations. And what we also see very much in this case law is just how much platform is really contributing to further developing, I think, the concepts that we have of employee, but also of employer, as we will see and when I'm going further, under national law. And yes, I'll try to exemplify that by this kind of methodology of criteria that I developed for the European Commission. So on this slide, what you can see basically is that at least in a number of countries, we already have decisions actually at last instance level. So it's actually only the UK that has this full instance structure. And also these are basically all last instance decisions, or really the highest courts of the countries in many EU member states have actually already dealt with questions of platform work. What is really fascinating when we look at how the higher instances are usually relating to the lower instances is that I haven't found a single decision where a higher instance court has said, has reverted a decision of a lower instance court that had classified a platform worker as employee. So usually it's either usually confirming, or it actually goes further and says, well, this is actually an employee, although the lower instance decisions did not go in that direction. So that's also an interesting kind of finding here, that the higher instances tend to go further in their categorization. And sometimes they're really opening up new avenues of interpretation that haven't been here before in relation to platform work, because that is kind of the one area which really exemplifies, yes, how work is changing and how perhaps the concept of subordination also has to be reinterpreted in many national systems. So that's one of the interesting findings that I could place at the beginning of this presentation. Yes, perhaps just to sum up a bit, to give you kind of an overview of the outcomes for different kinds of platforms. And here we're seeing actually the bulk of the case law. So you've seen it's like more than 170 decisions that I'm dealing with. Bulk of this case law is really concentrated on just two types of platforms, and you have them here. So it's first of all the ride-hailing platforms, the Uber type platform, and secondly these delivery type platforms. Usually it's food delivery, sometimes also parcel and grocery delivery, but that's really what makes up about like 80–90% of the case law that I've found. So that's really the area where we have most case law. And it's actually also the area where a classification as employee in the end is most likely in the decisions that we have up until now. This is, so first of all, for the ride-hailing platforms, the Uber type platform, we actually have a relatively consistent classification, so where all the decisions that were issued up until now classified the platform workers as employees. Yes, in 4 countries, and still relatively erratic case law actually in Belgium and France. So there are only 2 decisions in Belgium and lots of decisions in France, which are contradictory actually. So I'm always struggling with French case law. Yes, and actually the tendency towards a classification as employee is even stronger when it comes to the second type, so the delivery platforms. And that's interesting, I think, and might come surprising for many of those who read mainly the English language literature, where usually the UK's perspective is kind of overrepresented. And of course, in the UK, you might know it, we've recently had the 3rd instance judgment, which once again said delivery riders are not employees. That is an outlier position. Actually, we have many other countries. So in these 4, I would say I see first signs towards a classification as employees. It's not higher instance courts, but nevertheless you have the first signs. And in these 4 countries, actually, you also have higher level case law. So in the Netherlands, second instance, and in Spain, France, and Italy, you even have last instance judgments that confirm that, yes, delivery riders are actually to be classified as employees, or in the Italian case, you have heard it before, it's actually something very close to employees, it's a third category. Yes, much less case law relates to other types of services, and here I'm basically categorizing them as services in private households. So here that's mainly, on the one hand, the cleaning platforms. So here we've had Helpling, Happy Helpers, Hilfer, and Lastbit. That's the name of the Norwegian platform. Here we have, courts are really struggling to see an employment relationship. And in the end, in all of these cases, the higher instance or all the judgments at all have so far classified them as not being employees of the platform. So it then depended on the platform's specific regulations, whether or not they were seen as employees of the customer or just as self-employed, but not employees of the platform. And the same thing is currently most probably happening to the Swedish cases on these kind of handyman services. So that is the Task Runner and TipTap type platforms, where the platform worker is basically doing all kinds of household related, errand running tasks. Yes, here also we will probably not have them categorized as employees in the next instance. So for Task Runner, the first court decision actually already revised an administrative decision to this end. Yes, and when it comes to services delivered to businesses, we have actually even less case law, and it concerns very different types of platforms. So it's really, really difficult to draw any conclusions on that. It's just very individual decisions, but it's beginning to focus more, I would say, on those crowdsourcing, so types of platforms where we're seeing first signs that on-location microtasks, so not that kind of crowd worker where you're just sitting in front of your laptop and doing work online, but where you are doing on-location microtasks such as mystery shopping. We're also seeing a tendency already towards classification as employee, which might, in many cases, have come as a surprise. So here the German Supreme Court's decision might be the most well-known, of course, in international literature. Yes, I should go really fast. So I will skip all of those slides. I have in my analysis, and whoever is interested in that is very welcome to just drop me an email, ask the organizers of this conference. There are some interesting conclusions regarding third categories, which are, of course, very much discussed in relation to platform workers. Also, the role of legal presumptions, which is very different, actually, in relation to different platforms. And also different outcomes, actually, no? I'm going into the wrong direction. And yes, and multi-party relationships, because that's very difficult, actually, because for some types of platform work, the customer actually has also a very decisive role, and not only the platform itself. Yes. I guess I have 5 minutes left just for the typology, which was going to be the main part of my presentation. Yes, so let me go through it just very, very briefly. Yes, what kinds of criteria are really used by the courts? So first of all, I'll start with what is usually not the most interesting part. And what is, well, we really see a tendency of decreasing importance is, first of all, the contractual design, designation, and the will of the parties. So less and less attention is paid to that. Very famously, I think in the Netherlands, very recently, we had that last instant judgment that really said, well, the will of the parties is not decisive at all when it comes to classifying something as an employment relationship or not. It's only the facts of the case. It's only what is actually happening in that contractual relationship and the economic reality of that. So that is one relatively clear direction. What is also less and less important, I would say, is the question of exclusivity, non-compete clauses, where the question is, well, you can, as a platform worker, usually in modern types of platform work, you can work in parallel for as many platforms as you want, and many are doing this also. This used to play a larger role in past case law, but it's less and less taken seriously as a major criterion for deciding whether or not they are workers or employees. When it comes to personal work performance, as I already told you, the UK is really the outlier here, because this is really the one reason why delivery riders are still not employees and not even workers under UK laws. We have differentiation there, but not even workers under UK law, because they have the entitlement to be by anybody, and basically, at least according to the contract, this substitution possibility is really very wide. And the interesting thing is that actually in all the other countries, we have approaches by the courts to say, well, although, especially for those riders, in theory, the right to use substitutes, also use assistants, is very, very wide. Yeah, we're not taking that into account as a major factor, especially because, for example, we need to, or at least you need to notify the platform. Some courts would even say that the very fact that it's just really used is enough to say, well, this is actually essentially personal work performance. And very interestingly, I found this approach in the Netherlands of the second instance court also very where it just said, well, in fact, you can't use this kind of replacement option in an entrepreneurial way because you can't have yourself replaced by as many others as one. You can just pass on your mobile phone to somebody else, and then they will probably do the work. But it's not like an entrepreneur who have the option of just using as many assistants or replacements as they want. Yes, and the main issue, I would say, apart from that personal work performance in the UK, is really the question of an obligation to work, because that is, in a way, in all the jurisdictions that we have in Europe, that is really a key component of being an employee or not being an employee, and that is simply missing in platform work. And here we see lots of interesting and partly very creative ways in which the courts have really gotten around that point that basically there is no obligation to work. People can work whenever they want. And very often this is simply related in the more recent judgments, it's related to the lack of a real entrepreneurial activity on the part of the platform worker, where courts simply say we have to reinterpret that traditional criteria that we still have in our traditional definition of an obligation to work, and say, well, if it can't be used, this decision on whether to work or not and when to work, if it can't be used in any really entrepreneurial way, because the worker is in that system, which is so much dominated by the platform, yes, the obligation to work simply has to be given less weight in the overall assessment. In the end, we're always assessing it all according to several criteria. Yes, now I know my time is already almost up, so let me just very briefly mention the things that usually point in the direction of an employment relationship are, on the one hand, the direction and control criterion. That is becoming more difficult, I think, because platforms are evolving. They are making it, they are consciously adapting their systems actually in order to get rid of the direction and control criterion, because they are also realizing this is what courts are very much looking at. So that is actually becoming more difficult, I would say, in the case law. What is becoming more important, and what will probably in the long term play much more important role, is the question of organizational integration versus entrepreneurial independence, where many courts really do a very in-depth analysis of whether or not people appear as an undertaking, whether they use the equipment and so on. So I'm really, yes, I really have to rush to the conclusions already. Maybe just to mention it, there's a few decisions, very few actually, which really focus also on the principle, because under national law, usually the main question is only about who is an employee. And this is also what I think is particularly pertinent to this conference, because it's about the employee and the employer. And then some courts, and especially the German Supreme Court is, I think, very much the most interesting decision in this regard, really, which really says, well, what we have to look at is not only if that individual that does the task has all kinds of freedoms, because they can choose when to work on and how to do that and whether to work at all, but we also have to look at the company and whether the company can really use its workforce in order to deliver on all its orders that it has, and in order to provide a specific service. And if that is the case, we should see it as an employment relationship.
Okay. Thank you very
yes,
much.
and then I had several conclusions, but I guess I don't have the time to really go into my ideas on that. We might go back to those, yes, in the common discussion then. So yes, thank you for your attention, and I'm looking forward to more. Yes, to the last presentation. Thank you.
Dziękuję bardzo za bardzo wyczerpującą.
Thank you very much for a very extensive presentation. Congratulations, because I can see there was a lot of effort into systematizing certain issues and this comprehensive, holistic approach to the issue of regulations of platform workers. And now it's time for the last speaker. Now it's time for Dr. Olga Chezalina from Max Planck Institute for Social Law and Social Policy. As far as I remember, during the first conference, you were present in Rzeszów, so 15 minutes for you, traditionally. If it's possible, please stick to time limits, because we are already delayed. Thank you. Do we have Dr. Chezalina online? Do we have a connection with the next speaker? All right, so the floor is yours.
Thank you very much for the introduction and for having me here. Please confirm whether you can hear me and see my presentation.
I can hear you and see presentation. Okay, everything is...
I would be very happy to be in person.
Is all right.
Oh, thank you. I would be happy to be in person in Rzeszów today. I still have very warm memories from the first international conference in Rzeszów 3 years ago. The project I want to present today is a work in progress. I'm just at the beginning of my research on this subject, so I would be grateful for your comments and questions. And I would like to start by explaining the topic of my presentation, which I slightly changed to formal and effective coverage in labor law. This approach refers to social law. In social law, a distinction is made between a formal and effective coverage on social protection. Formal coverage in social law means to be formally entitled or even obligated to participate in a certain social security scheme. In the EU Council recommendation of 8 November 2019 on access to social protection for workers and self-employed, it is recommended that the member state should extend the formal coverage to all workers on a mandatory basis and to self-employed workers on a voluntarily basis, and where appropriate, also on a mandatory basis. And as you know, in many European countries, self-employed persons are often not insured in the insurance against accidents at work and professional diseases and in unemployment insurance. Gaps in effective coverage on social protection mean that despite formal access to certain branches of social insurance, due to unfulfilled conditions, for example, waiting periods or minimum contributions period, a person does not have access to social security benefits of a certain branch of social security. And often this is the case of persons in non-standard forms of employment, for example, platform workers, on-call workers. And I think in labor law, we can also speak about formal and effective coverage in labor law, even if we cannot automatically transfer the social law approach to labor law, since social law covers both employees and self-employed. And in my research, I seek to analyze the following issues. To analyze whether also in labor law there are gaps in effective coverage, to determine whether the potential gaps in effective coverage in labor law are similar to those in social law, and finally to find out the factors that negatively influence effective coverage in labor law. At first, I would like to show up some similarities in effective coverage in labor and in social law. The Council recommendation on access to social protection of employees and self-employed persons names some factors that influence the effectiveness of coverage. And some of these factors are relevant for labor law too. For example, rules governing entitlements. Also in labor law, we can find situations in which an employee, due to unfulfilled conditions of collective agreements, have no access, for example, to gratifications or to pension plans, because the employee does not meet the conditions stipulated in the collective agreement. Furthermore, according to the Council recommendation, differences in the rules governing the schemes between labor market status or types of employment relationship should be proportionate and reflect the specific situation of beneficiaries. And even if in most of the countries the labor law covers first of all employees, some European countries, for example, Spain, Italy, France, provide particular labor rights to self-employed persons or dependent self-employed persons. And for this reason, also in labor law, the employment status is of importance. And actually, different actors at the national, European, and international level seek to broaden the scope of labor law. And one of the goals of the UN Agenda for Sustainable Development is to promote decent work for all. And the ILO and the EU have both launched policies aimed at extending the scope of labor and social security guarantees to non-employees as a response to a changed structure of self-employment. And the decent work agenda of the ILO presupposes that decent working conditions can only be guaranteed if labor rights are secured as human rights. The European Commission is working in the same direction, and recent initiative of the European Commission is seeking to address the challenges related to working conditions in platform work, irrespective of employment status. Professor Valerio De Stefano points out that some ILO conventions and recommendations apply not only to employees, but also to self-employed persons and to persons in the informal economy. And examples include conventions on elimination of the worst forms of child labor, or conventions on prohibitions of forced labor or prohibition of discrimination. And at the same time, it is to emphasize that those ILO standards which apply to self-employed and to persons in the informal economy are most often formulated as a prohibition of a forced labor or of discrimination, rather than clear positive norms defining a special scope of regulation, for example, concerning working time. At the same time, the extension of labor rights to self-employed goes along with problems concerning the enforcement of such rights. And it was already stressed in many presentations that it is a huge challenge to find a person responsible for ensuring labor rights. Citing her authors, it is of course an encouraging vision that labor law could be embedded in and help to advance a regime of fundamental and universal human rights. However, as her authors himself stressed, for all the attractions of labor law reconceptualized and hopefully reinforced as a branch of human rights law, it would be a very different kind of labor law. There are different strong obstacles against such a transformation. Speaking about the extension of labor rights and social rights to self-employed, a certain tendency can be observed. For example, platform providers are ready to acknowledge some labor and social rights of self-employed workers, of self-employed platform workers. And this is to be welcomed. However, the situation is critical if in this way they seek to avoid the application of labor law and the recognition of platform workers as employees. And this leads me to the question of formal coverage in labor law. There is a tight link between the enforcement of labor law regulations and effective coverage in labor law. As Professor Davidov points out, employers are often reluctant to comply with labor laws and might look to evade them and to minimize their labor costs. Furthermore, it is not possible to separate completely formal and effective coverage in labor law from each other. It is because the extreme case of ineffective coverage in labor law is a misclassification of employees as independent contractors, which leads to non-application of all labor laws and non-enforcement of labor law regulations. On the one hand, one of the permanent tendencies in the history of labor law was the attempt to extend the scope of its application. And on the other hand, employers seek to minimize their costs by outsourcing many of core activities to contractors or to platform workers, pushing persons into civil law contracts, with other words, contributing to the development of bogus self-employment. And from this perspective, some labor law policies can, only with a reservation, be considered as extension of the scope of labor law. This implies basically that the coverage of labor law has been narrowed in the first place and now is going to be broadened again. Platform workers call in question the criteria for the employee classification as a basis for the inclusion into the scope of labor law. And the question of algorithmic management and control was already stressed in many presentations. I would like just briefly say that just a few years ago, it was unclear whether algorithmic control mechanisms create a completely new kind of dependence or a new kind of economic dependence or just a new expression of personal dependence. Already there are many court decisions that consider algorithmic monitoring as an expression of personal dependence. And it is interesting that the European Commission consultation staff working document of 15 June 2021 and the resolution of the European Parliament of 16 September 2021 on a possible action concerning working conditions in platform work regulate in details the principles and rules for the use of algorithms in work and for data management that should be observed irrespective of the employment status. For example, rules concerning transparency or transferability of ratings. However, algorithmic control is a new way of control, and command is not seen as a distinctive feature of an employment relationship. Another huge question concerning the formal coverage of law is whether a special regulation that addresses exclusively working conditions of platform workers is required, or if such a regulation should be extended to all forms of non-standard employment. I think it is difficult to answer this question in general, at least in countries where bogus self-employment and misclassification by employers is a widespread phenomenon. The right solution would be to tackle bogus self-employment in general. And my next point is factors that influence effective coverage in labor law. I don't pretend to cover all factors that influence the effectiveness of coverage in labor law. I would make only two examples. For example, the form of work organization can be reason for different coverage on labor law guarantees. COVID pandemic with massive use of remote work is a good example. For example, we can see that different benefits are often provided for employees working at the premises of the employer and at home. These benefits concerns the possibility, for example, to get free or subsidized food or beverages, or the use of equipment of employer, including equipment that ensures healthy and safety working place. The next example is unclearly defined scope of application of particular regulations. And I would like only shortly use the example of the draft directive on the right to disconnect. And according to the draft directive concerning the right to disconnect, this right should apply to all workers and to all sectors, to all workers irrespective of their employment status. And at the same time, in the draft directive is provided that this right is an inseparable part of the new working patterns in the new digital era. And workers, and furthermore, the draft directive refers to workers who use digital tools for work purposes. And it is questionable whether workers who do not use digital tools, for example, gardener or cashiers, can realize the right to disconnect, or whether such persons can only rely on effective enforcement of the existing rules on working time limitations. And instead of conclusion, I would like to point out my next steps and goals. I hope that the analysis of the factors that influence the effective coverage in labor law will help me to understand the main tendencies and changes concerning the subjective scope of labor law in general and subjective scope of particular legal institutions and regulation, and help me to define measures necessary for the improvement of the effective coverage in labor law. Thank you very much for your attention.
Bardzo dziękuję za dyscyplinę czasową.
So much for adhering to the time discipline, and with this we close the series of presentations and contributions. So now is the time for questions. I'm afraid we don't have much time because I wasn't strong enough to interrupt such interesting presentations and contributions, so full of passion and engagement. And with that high engagement and involvement, so I'm asking right now, are there any questions to our panelists from the floor or perhaps online? So I would just ask very briefly every single participant. Perhaps I can start with Olga Czesalina. If I understood you correctly, you referred to Professor Davidov. So did you consider in your analysis his ideas of effective control referring to the behavioral ethics and certain behavioral concepts when it comes to influencing employers from the point of view of having regulations or rules for rig workers? And then my second question goes to Dr. Kristina Hisel and Dr. Naumovic. My question is it possible to have the optimum model of regulations for platform workers if we have these proposals to have that regulated at the European level? And here we had some examples of Spanish solutions. And there are quite many controversies that come with that, because the Spanish regulations presented here are at a contradiction to a certain extent to what has been suggested here. So we know the hierarchy of sources of the labor law, and we have this issue of global platforms. So which form of regulations should be assumed here? So that is like beyond the legal forms. I mean the networking platforms. And my first question goes to our first speaker, Professor Beryl ter Haar and Dr. Marta Otto. So you both presented a very cohesive and coherent vision of an optimistic vision of the development that offers many opportunities. And you said, Professor, that this is that historical opportunity for redefining the system. So do you think that there is a redefinition the opportunity of redefining the concept of an employee in that system when looking at trends or research when it comes to replacement of artificial technologies replacing workers? So this is just in a nutshell. I'm afraid you don't have more than 2 minutes per person for reply, because I'll be, I think, murdered instantly by the organizers, and I will not survive the conference until the very end. So I would appreciate your very brief response. Thank you.
May I start?
Okay.
Thank you very much for the question. I would like to say on the shortlist that I share the position of Professor Davidov, but I would like to stress that the effective coverage in labor law refers not only to the enforcement of labor law regulation. You can see it also refers to equal treatment in labor law, but it can also be issues concerning judicial technique, for example, unclear defined scope of regulations. And in my next step, I would try to to find a topology of factors that influence the effective scope of labor law in order to elaborate measures necessary to improve the effective coverage in labor law. Thank you.
Dziękuję. Może krótka taka odpowiedź pani doktor Kamili, pani doktor Krystyny.
Perhaps very briefly from Dr. Naumovic and Dr. Hisel when it comes to classifying platforms, when it comes to effective regulatory when it comes to platforms. So we can see that self-regulation trend by the judiciary in the case law, and now researchers they share good news about case law in different countries. So what is your view on that?
Yes, may I start perhaps?
Okay.
Yes, so first of all, so your first question, I would say definitely there is no one size fits all approach to platforms. And I think in my research, it's mainly those household service type platforms where you really see in the case law that courts are simply not finding themselves capable of classifying them as employees, even under very, very wide interpretation. Because with those platforms, you usually have workers who are very vulnerable and who definitely need protection in some way. But nevertheless, they arrange basically all the aspects of the work with the customer, the price, the precise tasks to perform. Yes, there's no supervision really by the platform, and the role of the platform is really enormously limited. And that's also why I would say, well, I would agree, for example, with what Marco Biasi has said in a previous session, that you need some kind of second layer. So classification as employee cannot be a solution, I think, for all platform workers. And nevertheless, I mean, things such as social protection or collective bargaining, things like those might in the end perhaps have to be granted to a wider, a wider, more broadly defined group of platform workers, even those who in the end we can't define as employees, because certain areas of employment law are simply difficult to apply to them, or in the end the platform just lacks the kind of control in order to comply with an employer's usual duties. And as for the Spanish solution, because you asked about that, I actually found it interesting, because in Spain, already before that riders law that we have talked about, actually the Supreme Court and all the other judgments, so for 2 years or so, all the judgments basically classified platform riders as employees. That wasn't the question that was disputed at all in case law. So in the end, that law comes a bit late, I would say, and therefore I have really thought it strange that it is really reduced to riders, because for the riders we really have that case law. For the others it would have been interesting, but for the riders it was actually not a question at all. And what we can also see in practice now with those platforms that would be affected, it's basically 3 delivery platforms that they have that are the main ones. They are not going to comply with it. So they are going to find different solutions. One of them is saying, well, I'm going to use subcontractors, so at least I don't have to apply the collective agreement. Another one is saying, well, I will just make them really self-employed. Let's see how that works. So in the end that they can determine their own price and so on. So that's something I've never seen for a delivery platform to do.
Yes.
Yeah, so the Spanish solution is certainly not the end of this discussion. Yes, thank you.
Dr. Krystyna, thank you very much. I dr. Kamila jeszcze poprosimy.
Dr. Kamila Naumowicz.
Yes, thank you very much. I think that my colleague just before exactly expressed what I was also thinking about, that it's really hard to talk about an optimal solution when we see that the solutions that have been applied in several countries just are not executed in practice, and that at the end the person that is performing the work remotely or the work through online platform is not protected. So this is the true questions, how to arrange and how to organize the effectiveness of the possible security and regulation applied to those platforms, not exactly just talking about the way to regulate it theoretically. And I am looking forward a lot to the next steps of the European Parliament and the European General Proposal on platform work, because it's still under discussion with social partners. And in fact, I am also looking forward to the exact proposal on how to address this question, and whether it will be only referred to some categories of platform work, like in Spain, or it will be treated in a broader way. But it's really hard to imagine a solution applicable to all types of platform workers. So thank you very much, and not to prolong anymore, but thank you very much for this question and for this discussion.
Dziękuję. Dziękuję bardzo.
I thank you. I was informed that Professor Berder and Dr. Marta Otto are no longer available on our platform. So I thank you so much, and I announce a break. So let us enjoy a short break, and then we'll meet again for the next panel. Thank you.
Dobrze. Szanowni Państwo, witam.
Gentlemen, let me welcome all of you very warmly. We are beginning our next panel. The conference has been organized by the University of Rzeszów. Our time is very much limited, so let me just say that I am very grateful to the organizers for organizing the whole conference. So many thanks to the whole team. We have now a hybrid conference, which means that we have online participants, but there are also some on-site participants and speakers. It simply means that we are getting back to normal. Everyone is looking forward to it. And we hope it is just a beginning of our return to normality. And we hope that conferences will go back to the reality. And let me just say that the University of Rzeszów has set a very high standard for this new round of conferences. It will be very difficult to match it, but we'll do our best. I'm very grateful for the invitation, and now let's begin the next session. In the previous panels, especially in the last two, we focused a lot on modern technologies, the fourth industrial revolution, its impact on the labor law, on work as such. We were talking about implications of the whole situation. I believe it is now the time to focus a bit more on more traditional problems, because the labor law has been dealing with certain issues for years. It is also important the fourth revolution is making its impact. That's clear. It doesn't mean, however, that the traditional forms of employment have fully disappeared. So we also need to debate that. On our agenda, we had 5 panelists. Unfortunately, we don't have a connection with Professor Svitlana Synchuk. That is why there will be 4 panelists in this session. Let us move on to Professor Reinhard Zenga from the University of Humboldt from Berlin. So the floor is yours. He is going to talk about the employment status of professional football referees. So the floor is yours, Professor.
Yeah,
Professor Zenga.
Yeah, thank you very much to hear me. And before I start, I wish to share the screen.
Przepraszam bardzo,
can you see it?
Excuse me, and one remark, a very important remark. Please keep the time. 15 minutes, it's maximum. Maximum. Yes, okay, thank you very much.
I try. Well, now, do you understand me and do you see my slides?
Yes, we see.
I don't understand you.
Yes, everything is okay. Everything is okay. We see your presentation. Thank you.
Yeah, you see it now. Good. Okay. Then let me start. Yeah. Thanks again for the invitation, and thank you very much for the opportunity to discuss the employment status of professional football referees. The topic, I think it meets to the general topic, but I have to admit the football referees don't belong to the type of vulnerable persons we have discussed in the previous panels, but they deserve, in my opinion, also protection. I skip my outline because 10 minutes is very short. I prepared 22 slides. So I start with the background. The background is, you have to consider that the relationship between referees and the German Football Association is based on the rules for referees, the regulation, and the DFB, the German Football Association, decided each season, prepared a list for each season, and in the list, the referees are appointed for the respected season. And the background of my topic is now that several referees have recently filed lawsuits against their removal from the list, and claiming that they are employees in a fixed term employment relationship. And another dispute was launched by Manuel Gräfe, a referee who has to resign in the age of 47 because the age limit of the German Football Association is 47 years. And the labor courts denied the status, the employee status, the employment status of the referees. So I try now to explain that the referees deserve the employment status. I already had mentioned that the referees and the DFB conclude a referee agreement for the season, for each season, and it is the content of this agreement is that the referees don't have any rights. There is no employment relationship is stipulated in clause 1, and the referees are not subject to any directives apart from technical and scheduling requirements. They are not obliged to conduct matches, but they are also not entitled to demand an assignment. And they receive a general schedule in the beginning of the season with a request to inform when they are not available. Unavoidable cancellations must be communicated 4 weeks in advance, and if in the case of repeated unjustified cancellations, sanctions may be imposed. The most important sanction is the removal from the list of the referees. According to the German legislation, I just emphasize that the criteria are those criteria we have discussed the whole day: personal dependence and instructions, subject to instructions are the main criteria to decide if the person, the respective person, is considered as an employee. Decisive is an overall assessment. The designation in the contract is irrelevant. So now to the status as employee. The previous literature, referees work for free. This is outdated, this opinion. The referees receive meanwhile an annual basic salary of 60,000 euros and an additional 5,000 euros per match. So they work for refereeing. Refereeing is work. The Court of Appeals denied that referees are obliged to work. the background is that there is a framework agreement which regulates the details for the conduct of the single matches, but does not itself create an obligation to perform work. Indeed, the Federal Labor Court in Germany recognizes that such framework agreements can be concluded without creating obligation, but prerequisite is that there is no coercion to accept individual orders. I don't agree with this position. On a formal view, indeed, the referee agreement stipulates that the referee is not obliged to take over the conduct of matches. However, it would be unrealistic to assume that the DFB would pay an annual basic salary of 60,000 euros without expecting a significant counter performance. Sorry. And secondly, wait a minute, no, I have to see now. Yeah. On the other hand, the freedom to cancel is not worth much because, of course, there's an obvious risk that the assignment will be not extended in the case of cancellations. And the Federal Labor Court has already recognized an employment relationship with program-making employees if they were expected to be on duty at all times, even if they are able to refuse orders in individual cases. The second argument is against the employee status, that a referee is free in the conduct of the matches. He has the final decision-making authority, but referees are, of course, required to observe the rules of the game and the guidelines for the interpretation of the rules. A parallel situation is given with teachers and lecturers at public schools. They are also free in how they teach, but the Federal Court, the Federal Labor Court, justifies their employee status by the argument that they are bound by a dense body of laws, regulations, administrative decrees, and individual instructions. So it is obvious that this is also the case here. So I skip now the huge number of duties for the referees when conducting the matches and mention only that the second criteria, the personal dependence, is obviously also fulfilled, because a typical characteristic for personal dependence is that the person is working together with a team of collaborators, don't use own means of production, don't use own staff, don't occupy staff, and don't have own capital. The fixed basic annual salary is an argument for the entrepreneurial risk, which is borne by the German Football Association. So the overall assessment leads to the conclusion, a very clear conclusion, that referees should be considered as employees, in contrary to the predominant position of the labor courts. What are the consequences? The consequences are a lot of consequences, but I just want to focus on one consequence. This is the application of the Part-Time and Fixed-Term Employment Act, a fixed term work, a fixed term employment must be justified by an objective reason. This is the main complaint of the referees who were removed from the referee list. They argue they are engaged in a fixed term employment. Fixed term employments must be justified by objective reason, as already mentioned, and the objective reason could be that that the nature of the work is so special that there must be an exchange of referees. According to the situation of football players and trainers, the fixed term contracts were justified on the grounds of unstable performance. And although this argument is not uncontroversial, I agree with this, and but would say that it makes sense to exchange players to improve the interaction in the team, the composition of a team. Is an argument for the necessity of exchange and limitation of the contracts. And comparable considerations do not exist in the assignment of referees. So this argument is not convincing, but I agree that it is there is a need of exchange of referees. The Commission decides each season which referees are nominated for the first league, the Bundesliga, the second league or the third league, and the classification must be based on the selection of the best. So this could be an argument in favor of the limitation, the time limitation of the contracts. But at the end, this is also not convincing, because the decision of the Commission is arbitrary, and an arbitrary decision does not ensure the selection of the best, of the most suitable referees. So this is at the end not sufficient to justify the time limitation, the fixed term contract for referees. So my conclusion in this point is that referees should be considered as employees. But if you don't agree with this position, there are two other reasons under association law that confirm the protection of the referees. The first argument is that the German Football Association is a mighty organization which has a predominant position over the referees. And in such relationships, there is an obligation to contract. And the obligation to contract does not only mean forcing access to the membership, but also to participation in events and facilities. And that means that referees must have access to the referee list if they can prove that they are the most qualified referees. And the obligation to contract is restricted if there is a objective reason to refuse a contract. But the objective reason, this is a question we have already answered, does not exist, because the arbitrary decision does not ensure that the principle of merit, which would justify the rejection of the referees from the list. This does not justify a fixed term contract, but justifies only a transparent organization, establishment of a fair and transparent selection procedure. And the same result is if you consider that there is a review of the content of association rules, because association rules of predominant associations are basically subject to a review of the content, and with this perspective leads to the same results. The rules must be adequate, and they are not adequate if they lead to decisions which could be arbitrary.
Professor Singer,
so yeah,
you have 1 minute.
Yes, 1 minute is okay. The second, the second issue is the age limit for referees, and I have only 2 arguments which are important in our discussion. The first one is that age limits could mean discrimination, and according to the general Equal Treatment Act, the AGG in Germany. But this this act applies also not only to employees but also to self-employed persons. Well, is it justified? Discrimination is not, can be justified. I skip a little bit, by genuine in determining occupational requirements. But this is not convincing. 2 reasons, and then I come to an end. The first one is that referees have to prove anyway each season their fitness, and the person concerned, Manuel Gräfe, has a high reputation because of his performance in the past, and it is not an argument that he is no longer able to referee. And the case law show that age limits must be justified by risk for third parties, and this is not the case here. So there is not a justification, and there is also, last sentences, a lack of necessity of age limits in international comparison. There are a number of countries where referees are not subject to age limits, and last slide, in comparison with the statutes of the World Football Association, they abolished the age limit of 45 in the year 2015. And so this shows that there is not a necessity, and therefore I think that age limits are not does not comply with the law. So this is a summary you can read in my abstract. The conclusion perhaps we can talk about this in the discussion. I'm looking forward to questions. Thank you.
Thank you very much for a very interesting presentation, and thank you also for the excellent time discipline, and also for the topic of your presentation, because it's about sport activity, and in my opinion, after several months of pandemic time, the sport activity is what we need much now. So let's go to the second panelist, Professor Catarina de Oliveira Carvalho. Hello, welcome.
Hello.
And
hello, thank you very much. First of all, I would like to
Yes.
congratulate the organization committee for organizing this event, and to thank you for the opportunity to participate, and also to greet my fellow panelists and all the participants. I'm also going to share the screen.
Okay, and please keep the time.
The time, yes.
15 minutes is absolutely
Okay,
maximum.
I will try to be very brief. So just presentation. Well, the scope of this presentation is to briefly present a specific contract that is regulated in the Portuguese Labour Code, which allows for an employee to establish an employment contract with multiple employers. I'm going to mention the guidelines of this contract. I will be more in depth in the final paper, in the written paper, and then evaluate its advantages or its potential advantages. And at the final of the presentation, I would like to establish a connection with the previous panels and talk a little bit about the applicability of this framework within the context of the digital platform work, since that issue is being discussed in the Portuguese context. Well, regarding the main question of who is the employer, the Portuguese legislation, as many other legislations, I think in most of the countries, don't have a definition of the employer and of the employee, but rather definition of the employment contract. This means that we have to determine who is the employer, and directly, and with reference to the legal subordination qualifier, which has been mentioned many times during the presentations today. If the legal subordination qualifier is attributable to more than one entity who jointly exercise the powers of the employer, authority and direction, within the same work schedule, receiving a single remuneration, we don't have several part-time contracts, we cannot identify different contracts, then a single contract, a single employment contract with joint employers should be established. Why should it be established? Because I think this is the solution advocated by principles of labor law. The principle of the primacy of reality. This is the only solution compatible with the legal subordination criteria, as it is established in most of the labor legal frameworks, and it is the only solution capable of guaranteeing effectiveness to employment standards. That means avoiding interposition phenomena that allow an entity to obtain all the advantages of being an employer and exerting the powers of an employer without being burned with respective charges. This is not compatible in general, of course, we know we have some specific situations where the law allows for this configuration, these legal institutions, such as agency work, but in general, this solution is not compatible with the principles of labor law. And this was the solution according to these principles. We had some case law in Portugal, as we can find in other countries, in France and Spain, in the United Kingdom or in Italy, that admitted joint employment relationships. In this context, however, we are going a little bit further the remedy approaches. And in 2003, the Portuguese Labor Code, it was the first labor code and then remodeled in 2009, decided to include a regulation of a specific contract that was not regulated until that moment, called a contract with a plurality of employers. So now the legislation regulates a specific contract which in general terms could be identified as a single contractual relationship. We have just one contractual relationship between two parties. So it's a bilateral relationship. It's not a three-way relationship we know from other configurations, from other legal institutions. But one of the parties, one of the contractual parties, the party of the employer, has a joint ownership of the employer position. We can have very many co-employers. This can happen over when the contract of employment is entered into by the employee and the employers, or can happen later on. We can have in the first moment a common standard, a classic contract of employment, one employer and one employee, and later on, with the agreement of the employee, this contract can be transformed in a contract with a plurality of employers by the addition of other entities to the position of the employer. Which were the main objectives of this regulation? First of all, solving the problems of the identification of the employer when we have a plurality of actors, and thus improving legal certainty. That way, we could establish the corresponding responsibilities. That means re-internalization of corporate responsibilities instead of the usual externalization, which would improve the employee's protection. Further on, allow small and medium enterprises to meet the needs of manpower that do not justify the employment of permanent full-time workers or cannot be fulfilled by fixed-term, part-time contracts, and even allow them to access labor costs, skilled labor, whose cost is too high to support alone by a small enterprise. At the same time, it could increase full-time jobs, favoring the regression of the precarious labor relationship, and support more flexibility for the companies, because they can have a framework that allows them to move workers or employees between different companies without putting at risk the labor protection of those employees. So this could credit the slogan of flexicurity, since it could give more flexibility to employers without harming the employees' protection. Nevertheless, as it happens in Italy, for instance, we have a limited scope. This contract can only be concluded between employers who belong to the same group of companies, or else an alternative, have a common organizational structure. So they can be individual employers, they don't have to be a company. The only requirement is having common organizational structures, which the law does not define. At the same time, formal requirements must be met. The contract is subject to written form and has some mandatory content. namely the elements of the contract that may raise more problems, the activity of the employee, the place of work, working time, and in order to attempt to resolve the problems that may arise from the multiple employer situation, they have to indicate in the written contract one employer represents the others in fulfillment of the duties and the rights arising from the employment contract. If such requirements are breached, the law states that the employee has the right to opt for one employer. The employer has to choose, he can choose to be linked only to one employer. So the consequence will be the reconduction of this contract to the classic employment contract between one employee and one employer. Of course, the main practical impact is establishing joint liability. Employers are joint and severely liable for all the obligations arising from the employment contract regarding the employee or third parties, namely Social Security. No regulation is established regarding the active side of the employment relationship. The more complex problems that arise from this configuration where we have multiple employers regard the exercise of the powers of the employer, who can, or what to do if they, for instance, have contradictory orders. In the moment of the termination of the employment contract, all the employers have to terminate the employment contract. Only one is enough. The employee's duties, the enlargement of the employee's duties, and the collective agreement applicable, which is very commonly a problem. And this kind of problems can keep companies from concluding this kind of contract since they feel insecure about the regulation of many of the problems arising from the relationship. Finally, one note regarding the relevance of this contract in the context of digital platforms, specifically in the context of ride-hailing digital platforms. And this is relevant since Portugal has regulated this reality of ride-hailing digital platforms through a law in 2018, known as Uber law, since it was the first ride-hailing platform to function in Portugal. With this law, the Portuguese legislator managed to shield the digital platform from all employment disputes. That's why we don't have any case law. On the contrary of many other countries we have heard about today, in Portugal, you don't have any case law regarding the qualification of the riders, the employment or the other or different qualification of the contract. Since according to this law, only a legal person can be bound to a ride-hailing platform. It's not possible for the rider to enter in a contractual arrangement directly with the platform. It has to, we have the mediation, which is imposed by the law, of another entity, which is the TVD operator. TVD, it's an acronym, a Portuguese acronym for transport of passengers with unmarked vehicles. So we have a legal person who is going to bound, I'm going to show, it's easier that way. Between the digital platform and the drivers, we'll have we don't have the three-way relationship typical in other countries, but we have a fourth entity, which is the so-called, by the Portuguese legislation, TVD operator, who must be a legal person. So the TVD will establish a contract with the driver. The driver can be, it can have an employment contract or can be an independent contract, but not of the digital platform, but rather of this mediator, the TVD operator. And the platform will contract this TVD operator. That way, the problems that when arise, they don't concern directly the digital platform, but rather the mediator, the problems regarding the qualification of the contract. In this context, it seems that this law only provides joint liability of the platform towards the user, not towards the drivers. And as I explained, we have yet until the present moment no case law for this reason. The possibility of having fragmented exercise of the employer's position. We have already heard today some interventions regarding the algorithm as a boss and the control power exerted by digital platforms. If we can find that the position of the employer is fragmented between the digital platform and the TVD operator, legal literature is pointing out to the application of this specific framework of the plurality of employers. That way, it is possible for the driver to have two co-employers who are jointly responsible for all the obligations arising from the employment contract. Thank you very much for your attention. I will be at your disposal for any questions you have or for further explaining or developing these ideas. Thank you very much.
Bardzo serdecznie dziękuję za tą niezwykle interesującą prezentację. I chciałbym prosić...
Very much for this highly interesting presentation. Now I would like to ask the next speaker to present her paper. It will be Dr. Małgorzata Mędrala from Kraków University of Economics. She's going to talk about the competition in the labor market and social burdens for entrepreneurs.
Proszę Państwa, tak, już chyba miałam ściszony głos. Chciałam się najpierw upewnić, czy mnie widać i słychać.
I guess my mic was off. I guess I'm back. Can you hear me? Can you see me? We can see Kraków, but we can hear you very clearly. All right, first of all, I'd like to say thank you for this possibility to participate in your conference. And I'm glad I will be possible to deliver my paper. Ladies and gentlemen, I'm going to talk about competition in the labor market in the context of social burdens for entrepreneurship or the employing entities. Why is that so? Competitiveness is among the basic qualities of enterprises, which allows for attaining competitive advantage over other entities, especially from the same sector. And competitiveness may be achieved by price, by products, by skills, or knowledge. Undoubtedly, it is influenced by the selection of the right form of employment of employees, be it employment contract or non-employment contracts. Undoubtedly, employment contract is connected with the highest range of social benefits for an employee and at the same time for the biggest social burden for employers or entrepreneurs. So the selection of the right form of employment every time will be conditioned by costs, financial costs, but also organizational costs, because as a result it will be translated into the price of a service provided by entrepreneurs. Employment contract is always connected with a range of advantages or social benefits for an employee. There are financial benefits for the employee, which are at the same time burdens for employers. So these are social benefits which are not directly reflected in their work, like holiday leave, sick leave, severance pay, paid sick leave, or costs of medical care, health and safety, training costs. So they are called social benefits or social transfers. And these costs are incurred by an employer, which generates additional costs of employment for an entrepreneur. Additionally, there are many obligations of organizational nature. If there are big employers, there are various premiums, like for the disabled fund or remuneration for various remuneration brackets, various remuneration groups. So entities which employ employees are becoming slightly less competitive in the labor market when it comes to the price of services provided. And very often, there are cases in practice, especially in the transport sector or IT sector, that the same entities take part in tenders, but they use various forms of employment. The question arises, is there any possibility to question by another entity the question forms of employment of the personnel in tender procedures? And what tools, what legal tools, bypassing employment contracts like self-employment, what tools are applied there? From my perspective, these tools are quite weak. In many cases, there is a question whether self-employment is acceptable in some situations. But a possibility to question if this form of employment belongs to the entity which employs and to the person providing services. It is not necessarily in the interest of any of these parties. And there are no too many cases of questioning forms of employment in other employers or in other entrepreneurs. It is also about public and legal issues because it is connected with certain fees and payments for the state and premiums for the state by these entities. So this issue is also related with constitutional principle of proportionality in the employment law, because imposing any burdens which are not directly reflected in the remuneration of an employee, so social burdens, as we call them, interfere in the freedom of business activity, in the freedom of concluding contracts, and in the right to ownership. And there is an issue of interaction between the labor law and the economic law, as well as social rights and freedom of the labor market. In this context, these issues have to be decided in the context of the principle of proportionality. And there was even an idea of the Codification Committee of the Labor Code of 2018 to, while interpreting the provisions of the Labor Code, they wanted to apply the principle of proportionality, taking into account the right to work or the freedom of running your business activity and the need to attain social goals. As for social protection of self-employed, undoubtedly we can notice that there is a certain trend of the legislator, at least for the last several years, which aims at transferring legal protective regulations from employment relationship to the self-employed. So there is broadening the right to be associated of the self-employed, the right to health and safety, healthy conditions of work, equal treatment or parental rights. As for rights which are typical social rights which are guaranteed in recent years to the self-employed are actually minimum wages for the self-employed, where in the law on minimum wages, the legislator introduced provisions according to which the minimum wage per hour for a person who performs work or provides services under the economic activity and business activity, who does not employ its own employees or who does not conclude contracts with service providers, must amount to the minimum hourly wage. So in this context, there is another problem, namely a problem of the lack of definition by the Polish legislator of the notion of self-employment. The best example can be the law on minimum wages for work in the context of tax regulations which define non-agricultural business activity. In the law on minimum wages for work, a person who is self-employed was defined as a person who performs services for an entrepreneur or any other organizational entity under the business activity and does not employ employees or other service providers. And the notion of an entrepreneur was defined by an adjective of performing organized work on their own behalf in a continuous work. So for a self-employed person, doesn't have this requirement of organized work, but in the definition of the tax law, Article 5A, Item 6 of the tax law, income tax law, on physical persons, a business activity or non-agricultural business activity is understood as manufacturing, constructing, service providing activity, which is about looking for, extracting, deposit or manufacturing non-material goods or material goods, which is conducted in your own behalf regardless of the results. So there is again the adjective organized work, and there is also this notion of continuity pertaining to every employed person. So it seems that the definition is not cohesive with the previous definition. In tax regulations, the regulator foresees, due to fiscal reasons, foresees a certain mechanism which aims at bypassing self-employment, replacing employment contracts, and it is shown in a negative definition, a non-agricultural business activity, Article 5B, Item 1 of the physical person's income tax, which stipulates that such an activity is not the activity where there are three conditions met at the same time: responsibility towards the third party as to the result of the activity, or performing work without any responsibility for penal acts from the ordering party, or supervision by another party in the place and time from the like mentioned by the ordering party, and there is no entrepreneurial risk connected with their business activity conducted. With this definition, it is enough not to meet one of the premises to be unable to have self-employment, like lack of flexibility of time and place. And a certain attempt to define self-employment was made in the case of transportation drivers. And here I quoted Article 3, letter E of the Directive 2002/15 of the European Parliament and Council of 11 March 2002 on organization of time of work for people performing activities on routes in road transportation. This example is quoted for a reason, because very often in practice there are situations that in tender procedures there are entrepreneurs who deal with transportation, road transportation. On the one side, there is an entity employing drivers on the basis of employment contract. On the other hand, there are drivers working on the basis of self-employment. And such an entity with employment contracts initially is losing out due to the costs of services that they have to incur. In the directive, what is interesting is an attempt to define self-employment. And the quality of self-employment is that the driver who is self-employed, unlike the driver with an employment contract, who is an employee, is not connected with an employer by means of employment contract or any other hierarchical structure, but may independently organize various activities whose income depends directly on the profit worked out, and has a freedom of maneuver by means of cooperation with drivers who are self-employed to maintain commercial relations with multiple customers. So there is a possibility of working for more than one customer. 2 minutes left. All right, I'm moving towards the end of my presentation. So there is a possibility to work for more than one ordering party or more than one entity. As for case law, from common courts, these verdicts pertained to civil law contracts. Then there were more verdicts questioning the formula of self-employment, but these issues pertain to the situation where on both sides there is an employing entity and self-employed entity, which questions legal status for the benefit of employment status. And the real content of employment status, apparent nature of the contract are mentioned. All these provisions of tax law about the responsibility to third parties quoted. There are no other regulations which would allow entrepreneurs to question this formula among themselves. I think what is unacceptable is to quote Article 159, because it would be very difficult to prove their legal interest, and it is very difficult to establish a mandate, to establish a mandate in this context. But some seeds of regulations are in the law on public procurement in Article 95. On the public procurement law, there is a provision which stipulates that the ordering party in the announcement or documents for a public procurement should specify requirements connected with implementation of the order in terms of employment formulas by a contractor or a subcontractor of people performing specific activities in terms of implementing the order if these activities are about performing work in a way which is specified by the Labour Code. Against this background, there are several key problems, like qualification of employment, because then it becomes the duty of the ordering party. It seems it is not absolutely necessary, because interpretation of the Public Procurement Office refers to the verdicts of the office which were issued in various cases in common courts. But if we don't apply this formula of employment mentioned in the announcement of a public procurement procedure, may lead to the situation when we have various consequences, including irregularities, which are system-wide irregularities, which result in return of EU subsidies. Let me sum up. The conclusions are as follows. First of all, the social rights of workers influence competitiveness in the labor market. It is connected with the interest, which is the public interest of the state, but also the freedom of business activity and the tools to question the selection of the formula of employment, especially self-employment, are very much limited if entities are not very much interested in that. Even though there are some public reasons, especially what is acceptable. Well, there are certain beginnings of regulating this issue in the public procurement law, and the last reflection in the context of current amendments connected with the labor law or employment law, whether we should broaden the rights, social rights, so in order to include other employment relations, or to employ efficient mechanisms to prevent pathologies in the labor market. I would say the other option would be more recommended. Thank you very much for your attention. Thank you very much for this presentation. It was a highly interesting presentation. These were very important topics, and now it's time for the last speaker. The youngest speaker, PhD candidate. I don't know whether it is your debut or did you have any paper in other conferences. Oh, okay, so not the first time. An experienced speaker. All right, the floor is yours. It is PhD candidate Jakub Grigutis.
Dzień dobry Państwu. Na wstępie chciałem podziękować za...
Ladies and gentlemen, good afternoon or good evening. First, I would like to thank you for inviting me to this conference. This is a great initiative and so interesting. In particular, I enjoyed the papers, contributions in this panel, and my topic will be slightly different from the topics presented here, because I'll be talking today about subordination in the legal context of delegating employees on the EU single market. So my presentation is divided into two parts. So first, I will explain the concept of delegation and its premises, because that is necessary to determine the relationship between the employer, which is delegated, and then we have the subordination relation. And then I want to emphasize certain practical issues which are connected to the fact that not in every part of the aspect of this delegation will have that relationship. When it comes to the concept, the institution of delegation, it's legal. It is legally defined in the Directive 96/71 on delegating employees on the EU internal or single market, and the definition is contained in Article 1, Paragraph 1, which presents three different types of delegation. And these types of delegations are markedly different, as one can see by looking at the description. So the first type of delegation, which are called the delegation for provision of services, it is a delegation of employees at their own account, and they work or operate between the employer and the seller of services. And what is the type of delegation? So that was initiated by the delegation of employees, and there was this that took place before the directive on posting of workers was adopted. So the posting employer goes with posted employees or workers to a member state to provide service to the entity that accepts that work. So it is a basis of a commercial contract, say a contract for construction services between Polish entrepreneurs and a German entrepreneur, where Polish employees, Polish workers go to build a bridge in Germany. And that requires work relation. And let me add that on the basis of the directive, we have that subordination to law of the accepting or receiving country. So this is the receiving country that determines whether a person is or isn't a worker. So in principle, and its definition may vary between jurisdictions, as well as labor court case law may vary. So the contracts, these could be B2B contracts or contracts on the basis of civil law contracts, but in such cases, this subordination is required. But issues arise when we move on to two other types of posting workers. So then we have intra-corporate delegation, which is in intra-corporate delegation when employees are posted to an establishment or to an undertaking owned by the group in the territory of a member state, provided there is an employment relationship between the undertaking making the posting and the worker during the period of posting. And here we have a certain difficulty because we're posting a worker was say a mother company. The mother company is posting an employee to its daughter company. So let's say that we're posting a team of Polish IT people to a daughter company in the EU so they can learn programming together and also work for the company to which they're posted. So here, this is not pure subordination because they do not, these workers do not work under the guidance or do not fall under the direction of that company. There might be some form of communication between the mother company and the daughter company, but this relationship is not that clearly marked. So intra-corporate posting of workers is not that often described in the Polish case law or in the Polish literature. So for example, Dr. Cieszkowski, he writes that this subordination relationship does not exist in the intra-corporate posting of workers because in such case, such an institution would require that the employees, that the workers worked under the direction. So if we have this, so we shouldn't have that relationship between the parent company and the employee and the worker. But this definition is not entirely coherent with the standard definition of an employment relation that we have in the Polish legislation, so we have that subordination. And the final type of subordination of posting is a temporary employment undertaking or a placement agency when they hire out a worker to a user undertaking established by operating by in a territory of a member state, providing that there is an employment relationship between the temporary employment undertaking on placement agency and the worker during the period of posting. And then these workers are under the direction of the employer, of the user, who actually give the workers instructions, so they work under its direction. So that is the definition of worker posting and different types of posting. So that is in a nutshell. I could speak about it for hours, but so what are the issues here? So with the first type of posting, that could be a case that there is a work accident. And in case of posting workers in this service provision relationship, we have the directive harmonizing the HSC rules. Well, under that directive, it is the employer who is liable, who is responsible. So here we have this direction. But when we have a group of enterprises, and then we have an accident in a daughter company that receives posted workers, so the question is who is liable, because that should be the daughter company that delegated or sent out the employees, the workers, but on the other hand, that should be, well, that is the mother company that posted the workers. There is the daughter company that failed to comply with the HSC standards, or perhaps that was just a pure accident, unintentional and unwillful incident. So who is to be held liable? The parent or the daughter company? And so the liability in tort would be for the with the company.
Z uwagi właśnie na to, że występuje ta harmonizacja w zakresie bezpieczeństwa i higieny pracy, poszukiwać właśnie odpowiedzialności.
In the location when the accident happened. So here we have that we should look at the relationship between the posting and enterprise and the enterprise receiving the posted workers. And in my opinion, liability of neither establishments can be excluded. And then the posting enterprise undertaking must meet certain conditions based on the administrative law. So there are certain prerequisites of posting workers. So there are certain responsibilities that accompany that posting. So that is the obligation to notify, that is the obligation to have all the work relation documents translated, that is the obligation to appoint a contact person, and these are obligations to work with the body responsible for receiving that notification. So the question is whether we should look at it only from the perspective of the delegating entrepreneur, that is the posting employer, or perhaps there should be a different approach. So here we have, this question is answered by through the implementation directive, and in principle that is the posting entrepreneur or posting undertaking that should be held liable here. So, and obviously member states, they may also misinterpret the directive. So I understand I only have 1 minute. So let me move on to my conclusion. So as I said, that struck the concept of posting workers based on the concept presented in directive contains the concept of assuming a work relation between the posting undertaking and the receiving undertaking. But we should have a liberal approach to that and basically look at it on a case-by-case basis. And specifically, when in case of this posting workers to an establishment or to undertaking owned by a group of companies, then we should establish the actual relation between such companies, so that posting may just limit itself to posting the employee and receiving some reports on the employee's performance. In the 2 other cases, through agencies and direct posting, where that relation will exist. So I could continue, but I understand that there is a certain time frame or time limit. So I thank you very much for your attention.
Thank you very much. Applause for all the speakers in this session. Ladies and gentlemen, there are no questions in the chat, there are no questions in the room. Obviously, many questions may come to our mind because there were interesting presentations, there were interesting topics, but our time is limited, so perhaps we will continue this conversation in the future. And there will be more meetings, we will continue our discussions, and so for tonight it is everything. That's the end of the conference for today, so that's the last session today. Thank you very much indeed.
Szanowni Państwo, dziękujemy za dzisiejszy dzień w imieniu organizatorów i zapraszamy na jutro. Mam nadzieję, że dyskusja będzie równie owocna i obrada równie owocna jak dzisiaj. Dziękujemy bardzo i do jutra. Do zobaczenia.